All right, you're all set.
Good evening. Are we on?
We're on.
Okay. Good evening. This is the September meeting of the Board of Appeals, Village of Mamaroneck. Members present tonight are Brian Gladstein, Robin Kramer, and myself. One of our members, Greta Heaney, is not present this evening. She is out of state, across the country. And our fifth member, we have been without for some time because no one has been appointed for that spot. We also have our counsel, Charlie Gottlieb. Land Use Secretary is Brittany O'Neill. And can't see anybody else here. Let's see. Usually have our, maybe our building inspector here.
Frank?
Frank, are you here? Oh, you're silent. Now I can see your face, but I
I'm
can't.
here. I'm here.
Very good. Okay, good evening, Frank. Nice to see you.
Thanks.
Okay. Our procedures for the meeting, just to review them very briefly, are that we have public hearings tonight. We have about 6 of them. And when your hearing is called, if you would please indicate that so you can be called up on the Zoom, at which point, if you're a new hearing, please briefly review and present your application and the reasons to support it. We have your papers. And following that, please, also, the board will ask you questions. Please answer the board. Members of the public will be afforded an opportunity to speak. Speak to the board. You don't ask questions of the applicant, or the applicant doesn't ask questions of others. And then at the end of the hearing, either at this time or if the matter is adjourned, the hearing will be closed. After it is closed, what occurs is that the board will then deliberate and then render a decision. I would say that any new matter on tonight will, in all likelihood, not be the subject of any deliberation or decision tonight. Will come up at probably the next month's meeting. I would also point out that there are only 3 members here tonight. In order for an applicant to receive whatever the application is or have a resolution, it requires 3 votes. So 3 of the 5 members. We only have 4 members now, of which 3 are here, but you still need 3. So it's not a majority of the 3. It's our practice also that when this is rather unusual, but when this happens, if somebody wants to adjourn their matter, you can ask and we will review it. And if you want the adjournment, because some people prefer to present it to a full board, please indicate that now. Okay. All right. The first matter on the agenda tonight is an agenda matter of, and by the way, let me just say one thing, please. I think this is the most important thing. Because of the length of the items we have on this evening, if you've had a hearing previously, and this is the continued hearing, what you should do is please don't restate what you've said. That's really counterproductive. And quite frankly, it takes away from the attention to which you're entitled, because people say, we have heard this all. Try to present something new if that's what you want to do. And there's no obligation to, but if you're going to speak again, and that goes for anybody who wants to speak to an application. We're going to try to keep these tighter because we don't have that much time, and then it will run out and people will not all get heard. And we don't want that to happen. So we look forward to your cooperation on that. Okay, the first application is number 11, special permit 22 for 308 Mamaroneck Avenue. Is the applicant here? Okay. Well, this application was on previously. We were asked for and wanted information related to the open violations that were on the property. We have received none, which means I don't know if we can go forward or not, but Mr. Spatz, I see you're present when you're raising your hand. Very nice. I've never noticed that little hand that comes up on Zoom. How are you? Good evening.
Good evening, Chair, members of the Zoning Board of Appeals, Andrew Spatz for the applicant.
Okay. Before you, and I'm not interrupting you, I just want to tell you, before you go into anything substantive, I want you to address why we shouldn't adjourn this matter, because we're waiting on information.
Chair, I think they were transferring me up to you when you asked a question, so I didn't actually hear what the question was posed regarding what you were looking for. I
We were
apologize.
waiting for information related to the open violations. That was one of the items.
There should be, Chair, if I could, before we go forward, could we promote my clients so they can participate and be part of the application this evening?
Well, before we go on with that, I want you to address that item. If you wanted to confer with your clients, you're more than welcome to. I don't want to put them on the spot, but I want to know that because the inclination is that if we don't have that, I'm not sure we're going to go forward with it.
I can address that. The
Go ahead.
first
Thank you.
and foremost is on 8/18, I believe there was an updated parcel history, which reflects that the violations from 2021 were all dismissed and they all were closed out. With regards to the most recent parcel history, every single one of them was open past permit hours. There is absolutely nothing pending in village court at this time. And there's nothing for my client to do to close this out. It's not like a fixture or a component that needs to be re-inspected and certified. This is an event that alleged to have occurred on a certain date. There's nothing to cure. It's past, it's over. So in essence, either it has to be closed out by the building department or a charge has to be filed in village court, period. That's as it relates to those complaints. They're not up, these are things that we cannot cure. It's time has passed and it's already been done. And with regards to the matters pending before the State Liquor Authority, that matter is on for September 14th, where a disposition will be entered. It's a disposition that's global in nature, which will satisfy all matters that are were pending before the State Liquor Authority. My client has retained counsel on that. So that was a recent update I have from them. Lorenzo L. Angelino Esquire is the individual who's handling those. And again,
We were told that the last meeting. We know that.
and then we also have an attorney that's, they have an attorney handling other issues with regards to the village on other components. So this
What are
evening,
those components involve issues with the bill?
cabaret license, cabaret license. We have a meeting, there's council seeking, actually, that would be Christy Tom Dona from Silverberg and Zelantis. There's an email that was circulated with the village manager and Spalzino indicating that a meeting will be held regarding the cabaret license. And so we're moving along nicely.
So you want to proceed now is what you're saying?
Well, now that raises the next question, Sharon. And I think that I did hear. We only have 3 members tonight. Unless we're going to get unless we're getting an unanimous vote tonight, it would likely be in the best interest for us to push out to the next meeting when we have 4. Maybe by then we'll have a 5th, who knows? But that's Chair and members of the zoning board. That's the most recent information I can give you about the violations and where we stand.
Okay. So you want to put it on, we'll want to put it on for the next meeting? It'll be the October meeting.
Well, let me rephrase this, Chair and members of the zoning board. Unless you're satisfied by what I've shared with you, by the October, we will have gone before Liquor Authority on September 14th. The meeting will have been had with village manager and Mr. Spalzino. So I will have more information by the next meeting. So again, unless we're ready to close and you feel comfortable with the information I've shared. And I don't know if that's the case, Chair. I don't want to speak on your behalf or.
Right, I appreciate that. Thank you, Mr. Spaz. No, I appreciate that. I would say that probably best to come in after you've cleared the items, because there are items that'll be addressed.
Now, my only question to you is we have the renewal. Remember, so initially we came in for extending the hours as amending the original resolution. Then we came into a situation where we had to renew the original application. We recirculated notices and such. I think we're still under November 4th, November 2021.
Yeah,
Sorry, November 5th, 2020 was when the original permit was granted. So I think we're good.
I believe
we're
so. All right, any members concur in putting it on for the next meeting?
I think it'd be better off, we'll have more
Yeah.
information. It's hard to close, I don't think you want to close the item before you have
Yeah.
everything in your favor.
No, Mr. Glassing, that's exactly where I'm inclined to do. And if there's a way for the building department to close out those remaining items, again, which really should, unless they're going to go forward with additional filings. And actually, let me take a step back. If those items are part of the disposition of the liquor authority, and then that is resolved on the 14th, then they should be closed out. So I agree completely.
I
I
have a
would-
question. I was confused by something you said.
Sure.
No, there are no more violations from the village that have been correct. Is
I'm
that what
aware
you
of.
said? Correct.
As of this evening.
But instead but apart from that, you have all of these violations from the liquor authority. Correct? That are waiting to be heard right? You're going to, a lawyer is going to appear before whoever the judge is that is hearing those. But those
Administrative
are
hearing,
still-
administrative, yes.
But those are outstanding, correct?
Those are outstanding, but the ones, Robin, I'm sorry, Ms. Kramer, which I believe that are still on the parcel history were the ones that were reported to the liquor authority. So I guess my point is, on September 14th, when that disposition's entered, whatever dispositions entered and they're sentenced to, I truly believe that they could come back to the building department and say, this matter has since been disposed of, much like we did back last year in 2021, then those violations should be closed out.
Right. Okay. So we
Okay,
can-
so there may no longer be open violations, but these violations will still have been issued by the state liquor authority.
Ms. Kramer, I don't want to speak out of turn, and I would have to speak to Lorenzo and see exactly what does that mean when you dispose of a matter? Is it an ACD, meaning if you stay out of trouble, 6 months later it gets dismissed? Or was it a finding of guilt on charge 1, 2, 3, 4? I don't want to speak out of turn, Ms. Kramer.
All right, so you'll have better information next month.
I won't, Chair, I will.
I would also point out one thing to you I'm just going to give you, it's a heads up. Let's to be forthright with you. Unrelated to going to your client's premises, I was in the village. I go there very frequently in the evenings and the weekends. And on one occasion, 2 weeks ago, there was speakers by the door that could be heard 2 blocks away, which is how I heard them. And I'm not sure whether that's permitted or not. I'm not just going to tell you. And it was very loud. And the second time, I guess around 9:50 p.m. that the doors were open with music, this time not with speakers outside, but on the inside aimed out. So you might want to just at least be aware of that. And whether, I'm not suggesting it's permissible or impermissible, it struck some people.
Chair, thank you
Okay.
for bringing that to my attention. And
Okay. Very good.
as I've said in the past, we want to be good neighbors. And if you can hear it 2 blocks away in the evening, perhaps my client needs to be guided accordingly. So I
Okay.
appreciate you bringing that to my
Okay.
attention.
So this is going to be adjourned to the October meeting.
Very well.
We're all in agreement? Okay, thank you very much and have a good evening. And thank you, Mr. Spatz.
Well, I'm not going anywhere yet, Chair. I have a few more. Thank you.
Well, we'll see. Okay. Just get.
Trifecta tonight.
Okay. The next item is application 812, special permit 22 regarding 576 Mamaroneck Avenue, and that was that's the application for the that's for the restaurant, the fish
Yes.
restaurant. And the issue with that we had was that there was a question, it was on, I believe, last time, and it was adjourned because of a question that came up about whether there was a parking requirement. And what we have ascertained, and our councilors confirmed with us, is that the parking regulations do not apply to buildings constructed prior to April 1, 1968, pursuant to 342-55 of the code. And the documentation has been submitted by the applicant so that it doesn't comply. So I believe, unless the applicant is here and wants to go forward, that sort of closes the hearing. Is the
Judge,
applicant here?
Chair Newfield and members of the zoning board, good evening. Andrew Spatz. I'm
Oh, good evening
counsel.
tonight. How are you?
Good to see you again. Long time no see.
Yeah,
Hi.
everything good?
I am counsel. I have the pleasure of being counsel to the applicant. That's actually the owner of Jim Bellotta on behalf of Nelson Lopez of Harbor Fish Restaurant. And yes, indeed, you did articulate that correctly, Chair. I did submit, immediately having been retained, I submitted documentation articulating the fact that this was a pre-existing structure with the use. And I give credit to Ms. Kramer because she alluded to that 20 minutes into the former meeting. She made reference to the previous non-conforming. You guys were there, but now you actually have the documentation to make reference to. So I believe that it clearly reflected that there was a structure erected prior to the Village Code of 1968. It would be deemed pre-existing non-conforming. It was previously used as a restaurant, has always been a restaurant. And unless there's any additional information that I can provide, I think the hearing is still open. And I know my client, Brittany, could someone please just promote my client? Because I know they were very anxious and they wanted to be part of this evening's.
Just raise your hand, whoever it is.
Well, I was going to ask if there was a motion to close, but if you want to speak and you want to, I mean, is there anything to add to what you have been said previously to this date?
I know there was there was a tremendous amount of input from the public in support of this. And my thought process is this: if, again, Chair and members of the zoning board, if you're satisfied by the material that I have provided with regards to establishing that was pre-existing non-conforming, thereby not requiring a variance for the parking, I do believe I'm ready to close if you're prepared. My only request is that I would hope, and I would respectfully request that this evening, that a resolution, if indeed it was a draft circulated, it be reviewed and voted upon tonight, because I also happen to represent the landlord and they've been tenants since May 2022. And as with each month that passes by, they're paying rent and they would really love to be able to open their door. So I would preface and really respectfully request that this evening, based upon the simplicity of this application for special permit, that it be voted on. That's the only thing I would ask.
I think I can answer that. First of all, I think there's a misconception in the public that this application was held up. This application only came to us at the last meeting. We typically are not able to go through all the data, close the meeting, do deliberations, and issue a spot-on judgment because a resolution has to be created. And everybody worked very hard to determine whether or not there was anything that the applicant actually needed relief from. We were actually working on the applicant's behalf because if in fact the parking regulations did apply, we would be considering a variance to help out the owner. I personally don't think that there's anything else. This was the one issue. And I do make a motion to close the meeting.
Yeah, let me just comment as well. Mr. Wilson says it perfectly. I was surprised by all the emails. This application was dated, was signed in July, and it was on the first time. And people seem to think we were supposed to, I have no idea. They were arguing for it. There was no major issue other than an issue that we raised with you. That was the big issue we raised. And that's been addressed after the meeting. So I think people were somehow under impression, as was just stated, that was a misimpression. But because under any circumstance, it wouldn't have been, it would really never have been acted upon if it was on for the last meeting.
Chair, and Mr. Gladstein and Ms. Kramer, I respectfully understand what you're conveying, and I know exactly what you're making reference to. And immediately upon, as I said, having been retained, we were able to ascertain exactly what had to transpire. And I was very, actually cautiously optimistic that this evening, not only would we resolve this, but hopefully the matter would move forward. With regards to future applications regarding restaurants or anything like this, and I'm going to say this, I'm saying this as to chair and members of zoning board and any planning use committee in this community. I've said in the past, and I know you as members of the zoning board have sent memos to the board of trustees seeking revisiting our code to help facilitate a seamless return. And when you're not an attorney, you're not as a member of the zoning board, and you're not seasoned in the language and how the process works, it's understandable how one can get frustrated and one may not have the right and correct information. Bottom line is, the bottom line is,
Listen.
that's in the process is working. And this is something that in the future, we need to work on how to effectuate. I think our code's antiquated and we need to.
Well,
work
listen.
collectively.
Yeah, well, that,
Mr. Spatz, listen, we're here to help.
I know.
We're just village volunteers. This application had an error when it was submitted. It was submitted as if it was in the C2 district. And that's what led to the issue of trying to figure out whether or not parking regulations applied or not, because it's not in the C2 district, it's in the C1 district. And we have no choice but to go through the codes, rules, and regulations, depending upon what district it's in. So if anything, could be corrected, it is, to help applicants make things, clear in the first place, that they know exactly what district they're in and what regulations they have to abide by, so that we can actually get through it on the first shot. But again, I don't think that we need to have more discussion in this. I am making a motion to close this hearing.
Before
I have
I second it, I want to say, can we please stop having any discussion of anything other than the application before us? All of this discussion about whether the zoning code needs to be updated or anything is awesome and great, and some of it is really true, accurate. But can we just leave that alone for some other time, place, and not tonight?
Ms. Kramer, I agree with you, but that's why you received a lot of emails from the general public.
Hey,
I mean, I'm telling you as it is.
I
It's
didn't
not you.
receive any. I'm not on, the
okay,
village does not
I have
have,
a question, yeah,
I do not have access to the village
okay.
email, so I haven't received any, but
Okay.
the rest of you probably did, I gather.
Yeah,
Yeah,
there's
and
one
we can't do
question-
anything about the zoning code. That's not our purview.
Yeah. I have one question before we
I-
take that
okay.
motion, if we could, and that is, there's a question that came up in the drafting of the motion of the paper, and that is there an intention to have music in the premises or of any type, or amplified or live music? I assume not.
And if we could get my client promoted, that would be ideal. I assume that like every other restaurant in our community, we're not talking DJ, we're not talking acoustic, we're talking perhaps Sirius XM and background light music, nothing that requires a DJ or acoustic or anything like that. You go into the restaurants in the Avenue, and there's background music, but I don't want to speak out of term, so my.
Okay.
Great.
All right. So I think,
I think he's being promoted right now. You need to unmute yourself, my friend. Nelson?
Yes, I'm here.
Perfect. There was a question posed by the chair, whether or not you plan on having some background music, not acoustic, not a DJ, but music in a speaker, like in the roof, in the ceiling.
Yeah, that's the only music we're gonna have, yeah. Just the speakers.
and that would be just for background music?
I'm sorry?
Would that be for background music?
Yes.
Yeah, all right. Okay, thank you. Does anyone else on the board have any questions of this?
Speaking
Anyone?
of music, that's just inside and not outside, correct, the music?
Just correct.
Okay,
Thank you, Nelson.
okay. Is there a motion to close on this?
I think Brian made one,
Is there a
And I-
second?
and I will second it.
Okay, Brian? On the
Yes.
closing? Okay, Robin?
Yes.
I vote
Was
yes.
that public hearing closed?
The
previous?
hearing is now closed. Okay, so the hearing is closed on this matter. We will, I think we'll get to this resolution tonight.
Thank you. We appreciate that.
All right.
Thank you.
Okay, have a good evening, sir.
Right.
Unless the members want to deal with that resolution now that we have.
I'd rather just do it right now.
All right, given the nature of it, we have it. The only thing is that on the one item there, on the conditions on E, it should just indicate background interior
F, yeah.
F, I'm
I
sorry.
have a lot of comments on it, so, on the resolution. So if we're gonna
You
go
do.
through the resolution, well, not a lot, I have a few comments on the resolution, so if we're gonna go.
Well,
through
let's
the
just,
Yeah, well,
let's
let's
just get to it.
because that's what we'd asked to have these done before. Go ahead.
I don't know what that was. I received them today. So, whereas the proposed restaurant will provide dine-in eating tables. I don't know what an eating table is. All tables are eating. So I would remove the word eating. This is the third whereas clause. Then the next words are with limited outdoor seating. I don't know what limited means. And so it's whatever outdoor seating they have back there.
Could you direct us to what paragraph, please?
Third whereas clause.
Right.
Well, yeah, limited outdoor seating in the rear of the
Right,
premises.
what isn't limited, it's whatever they have there, it's not limited, it's whatever they have there, we haven't looked at the number, we haven't considered the number. There is outdoor seating in the rear,
Okay,
that's what there is, I don't know whether it's limited or not. If it's limited, what is it limited to? I would take the word limited out.
okay.
Then, as I recall, and I could have, my recollection could be wrong, nobody spoke, but I could be confusing my applications. Did anyone speak at the public hearing besides the applicant? I didn't recall, but I couldn't remember for sure.
Not at the, I don't think at the public hearing.
Right, so then where it says in the 1, 2, 3, 4, 5th, at which time the board heard all parties, I don't know what all parties is. It heard from the applicant, there were no public speakers or no members of the public spoke. I don't, otherwise, this is a little misleading because I don't know what all parties is. Okay, moving to 2 more down. So it's the 1, 2, 3, 4, 5, 6, 7th whereas clause. It says, just some language here, the existing building on the premises, it's not right to has existed prior. So, and we actually, and the zoning, what the zoning code says is not whether it existed, but whether it was constructed pursuant to a building permit issued prior. So presumably we need to say, whereas the existing building on the premises was constructed pursuant to a building permit issued prior to April 1st, 1968, and therefore, comma, pursuant to zoning code, the village's off-street parking requirements are not applicable to the premises, and that's it.
So you would combine those two whereas
Yeah, and I would
clauses.
revise it to reflect what it
Yeah.
is.
Charlie, you got it?
Yep, I got it.
Motion on this?
Wait, I think I'm just going through, that's
Oh,
it.
I thought you said that's
You're
it.
not done.
I'm done.
Oh. Okay, and for F on page 3, Charlie, were you able to put in what Dave had said about the,
Background
Music?
noise.
yeah,
Background.
Music.
And no noise in the outside. He said there was no noise in the outside. So
Yeah.
no noise in the, no music.
No music, no music.
oh, it should just be designated interior only.
Right, good point.
Now, we have commonly said that windows and doors have to be closed at 10 p.m. Now, I know they say the restaurant is closed at 10 p.m., but just in case, do we want to make clear that windows and doors have to be closed to prevent music on the outside after 10 p.m.?
Well, not if they're going to be closed.
Well, but except that the, hold on.
Where's the time on this one? what paragraph?
And
Well,
what they-
actually,
So the
Oh, it says
hours of
11.
operation shall be limited to 10 p.m., but customers shall leave by 11 p.m.
All
That
right,
means
so
you
then,
can
then
have
you said is good.
at
Yeah, that's
11
right.
p.m.
Yeah,
Right.
that's fine. Put that in then. That's fine.
so we should add that.
What did you say to add? I'm sorry, you broke up a little bit.
Oh, what I said was we should add that any indoor music, because that's what we're allowing, windows and doors will be shut that time to prevent the music from leaving. It doesn't mean, because obviously people are going to be outside eating at before 11, which I
So
don't,
windows and doors should be shut by 11.
by 10,
by 10.
because that's where the music is.
Okay.
I don't know, I haven't been in there outside, so I don't know how the access to the outside is, whether it's a wide open space or they have a door and it might make it a little difficult, but I think that's the only place I'm a little, be careful. Because there are some residential buildings reasonably close, I think. Not next door, but close.
Very good. Is there, with that understanding, is there a motion on this?
I move to approve as revised.
I'll second it.
Okay. Robin?
Yes.
Okay, Brian?
Yes.
Okay, I'll vote yes. This matter is approved. Charlie, if you could get me that resolution this week or Monday or something so we can file it.
Yep.
Thank you.
Okay. The next matter is 57, application of 886 Oriana Avenue. This is a continued hearing. We've received a lot of writing. If there's new material or someone wants to address something new, but otherwise I would just ask the applicant and the property owner to understand we will review everything. We have heard them. If you want to say something additional or new, or if board members have any questions, go forward now. So let's call this one on the. Is anyone here on
Is
this?
Sue, is Stewart on as well?
I just joined, I think.
No, I don't see him. If he's on, he just needs to raise his hand.
He'd be calling in from a phone number, if anyone knows what his phone number is.
914-698-7495.
It's not listed on the participants, so.
Looks like
Is
someone.
he under owner self?
Yeah.
Don't know.
Because I also have the owners of 886 who have raised their hands, so I don't want to promote the wrong people.
Don't know, but if it's better use of your time, I will proceed and hopefully he'll join. I think he,
Just give us 1 second. I'm just,
Sure.
have my, all the files of the office. Yeah, just look in the car. Okay. Yeah, go ahead, Ms. Corey.
thank you. Good evening.
Good evening.
I'm going to take your lead and not repeat anything. This is
Thank you.
obviously an appeal about 2 dwellings on a one-family lot. I'm going to pick up where we left off at the last hearing when Mr. Teeker and I reported that the original permit had expired in May of 2021, and the zoning board was told it had already been extended. We learned that one day after the hearing, on July 29, 2022, the property owners paid to have the permit extended. That sort of bothered me because both the zoning official and the lot owner at that time should have known that renewing the original building permit would create an unlawful second dwelling on a single family lot. So I'm just trying to correct the record in that regard. The renewal of this, so there was a more than a 2-month span with no permit, and it was renewed the day after the July 2022 zoning hearing. I did submit a fair amount of paper. One thing I want to emphasize is that the property owners themselves have the right to come directly to this board for a variance.
Yes, you had mentioned that the last time.
Yes, okay, so I won't go over that again, but I would like to just verbally request that our appeal be amended to include the extended permit. And I don't know, we have checked the parcel history. That should be in the record. It is not. I don't know if a C of O has been issued. But we would like the appeal to cover anything that happens with respect to this permit from a zoning perspective.
Before you go on, I have a question. Did the prior permit, the original permit, it expired? Now, when you say it was it extended in the documentation, or was a new permit issued? I mean, did that work from a technical standpoint? Do you know the answer to that?
It's described in the code. It's an administrative matter. It didn't work the way the code describes it. The permit can be extended up to 2 occasions for a 3-month period. This extension appeared to be extended it for a year, and it looked like a different amount was paid to extend the permit than what the code calls for.
But it was the same number. In other words, the building
Yes,
permit.
Yes, Robin, is the same number. It's
And
just when
it-
somebody pays, it remains with that permit. The permit is then extended. It's not a new permit. It's still the same number, same reference. They just extend the date in the system.
Even when it's expired,
Correct.
it's okay.
Never a new permit.
But
Okay,
the other permitting issue that we just discovered, I think today, is that there was no revised permit issued for the structural changes. So
There's no revision. There's no permit issued for a revision. When revisions come in, they're documented, money's taken in, but there is no additional permit issued by the building department for a revision.
so there is no change in the description of the building permit.
They keep the documents of record. We're working on that. That's something separate, but in the past, no, that was not the practice of the office.
Okay, so there isn't any paper that says that the structural work was approved by a building permit.
The stamped approved plan would be what references that.
Okay, that,
Along with the application that describes what they're saying.
Excuse me, could you identify Frank? Just say your name and then you can go. And why don't we let Ms. McCrory finish up unless you want to?
no, I'm just trying to say that we're trying to track what happened here. And we'd like, all the permits and the extensions to be included in our appeal.
When did you, Ms. McCrory, when did you say the permit expired? When was the expiration?
It was in May of 2021. I'm not remembering the exact date, like mid-May of 2021.
Okay.
It expired, I think, a day or two after our appeal was filed. At the hearing in July, we were told it had been extended. But when Mr. Teeger went to the building department this week, he got a copy of the receipt and it actually had been extended July 29th, the day after the last hearing. We're a little unclear on the revisions and when those happened because there've been a whole series of plans put in the record, some of which have been approved and others of which had not. So the first plans that went in weren't stamped received, they weren't stamped approved. And after we raised issues, new documents were submitted. Anyway, just want to kind of mention that. So I tried to address the standing issues that you raised, Mr. Neufeld, and Mr. Teekert submitted his timeline. I'm sorry he's not, Brittany, you're still not seeing him with his hand raised?
I see owner self. I just don't know if that's him, but I also have the owners of 886. So I'm just not 100% sure if that's him, if somebody could clarify. Or can I promote them? I just don't want to get in trouble for promoting the wrong person.
You
I
won't
don't.
get in trouble if you're trying in good faith to do something.
Thank you.
That's for sure.
Hi. Stuart Teekert is owner self. Did you hear that?
Yes.
Yes.
Okay.
Did you have anything you wanted to add, sir?
Yeah, I'm just wondering, if the ZBA received any ex parte communications on this application. I was informed that the building inspector at least had submitted a document.
I don't know. Let's let the building inspector answer that.
Are you speaking of an email or what kind of document are you speaking of?
I communicated to Brittany today, or yesterday, that I was told that in the middle of August, a email had been submitted to the zoning board and the board of trustees.
There was an email that was sent to the zoning.
By
board. That's
yourself.
true. Yeah, that's true.
I think, is that the one in response to an inquiry for having all the permits filed and the pertinent portions?
No, that was prior to that. It was
Okay.
in response to the original meeting that you had about this application. About the timeline, specifically Stuart Teacher's timeline.
So I guess my question is, will that be part of the record, and will I get a chance to respond to it once I receive it?
Do you have a copy? Does anyone, who was this sent to, Frank?
The zoning board of appeals.
Okay, I don't have my copy here. Brittany, do you have a copy?
I do, but I needed counsel to let me know whether or not I could post that, as it did come from an employee, not from the public.
Came from an employee.
It's my boss's email, so I did not know if I was allowed to post that or not.
Sure, it concerns this application. It was sent to the zoning board, I guess.
Yes.
Anything? Yeah, then go ahead.
Okay, I'll
Charlie?
post it tomorrow.
What problem is that?
Oh,
I guess in that case, I would request at minimum, the board, even if you close the application, you leave it open for comments on that record, which hasn't been made available.
Okay. Yeah, I don't have a copy of it with me. Charlie, do you have your copy?
May I ask one question? Does this document need to be foiled? Because I was advised of that by someone else. Is that true? It's an internal email?
No, because under New York State law, I believe all building department records are to go in, as well as the fact that all agencies and all parts of the state, village are supposed to cooperate, providing information. So, I mean, I think, Charlie, is that correct or not? But do
Well,
that?
there's a host of issues here. One is
What is that?
that inter and intra-agency communications are typically exempt from FOIL, but here we have a pending building permit appeal.
Right.
I'm assuming that email was commenting on the appeal, so that should be made available to the public pursuant to the open meetings law.
Right.
Okay, I'll do that tomorrow.
Mr. Gottlieb, I think only portions of intra and interagency records are exempted.
It's moot.
Other
because-
parts,
Okay.
That is correct. I can go through a course on the exemptions to the exceptions of the FOIL law, but
We're not here, what we're here for, excuse me. He's asked for a particular item. I don't have a copy here. I'm trying to get it as I speak. And you've indicated, yes, he can get it, and that's not an issue. What I'm asking for is so that he can have it at the hearing, is do we have a copy of that at all? Anyone have a copy with them, or I'm looking for one here. Does anyone have does any of the board member have access to that?
I could send it to you right now. I could forward it to the board as we speak.
Sure. Thank you, Frank.
It
Appreciate it.
came in August 15th.
All right.
Okay, I just sent it.
Could one of you please send it to me?
Okay. Frank, let's see.
So, Mr. Chair, I wondered if anyone had any questions for us after having read the material.
Um, I think you've addressed, I read all your materials.
If I could respond to this,
By the way, we also have to answer a question that you asked, and that was, is your appeal now going to be against and cover against the amended or the whatever we call that, was it the amended, the extension of the permit? The board have any objection to that or any feelings either way, Robin or Brian?
If,
We generally have allowed that, so,
I don't see what the difference is. I think that should be fine.
yeah, okay.
The only possible implication is, you know, the landowner said it's time barred.
Right.
Okay.
it's a-
They didn't actually have the permit until,
Okay, just a second. Let the board just discuss that, Ms. McCoy.
Okay.
I'm sorry. Brian, I have no problem with it. I mean, I would just include that in that this is also an appeal from the extended permit.
okay.
It is what it is. Brian, what do you say to that?
I think if the issue wasn't closed out and they still needed a permit, then it has to follow through to the current active permit.
And I do think it does, as I think Ms. McCrory is about to say, it potentially solves the time barred, you know, whether or not it's time barred.
Oh, yeah, we'll deal with that. Yeah. It is what it is.
Maybe.
Yeah, I mean, that's for us to take up a later date.
I didn't say it did, I said potentially.
Yeah, no, I agree. I think so. And if it doesn't, then it raises a question about the one that's expired. So it's probably best for everybody. I'm just looking here. I don't have that. Frank, did you, I'm looking here. I always have trouble with this, but,
You just sent it again.
oh, all right. Anybody else get this? Brian, did you get it?
What's that? Frank's email?
Yeah.
Yeah, I'm reading it.
Which is the date on your email, Frank?
8/15/22.
Okay, thank you.
Could one of you forward it to me, please?
Let's see. 8:15.
David, you should just be looking at, he just sent it.
I know,
again.
I'm looking and I'm seeing 9/8. Oh, that's the one. Okay. Begin forwarded message, right? But that's. Oh, is this? Oh, there we
Okay,
go.
Robin, I just,
Okay, I have
I
it.
resent it to you.
Yeah, it's addressed to the board. I wanted to address some misquoted information. Is that it?
Yes.
Okay.
I-
All right, that'll be filed, and I guess it's a little long to read to the applicant, and I guess if the applicant wants to address that, then, and yeah, then even if we close it, I guess he has every right to do so. Board agree with that or disagree? I mean, I would think he has that right.
I'm sorry, right to close?
I'm saying the applicant would have the right to respond to that,
Yes.
even if we've closed the hearing. I mean, that's what his comment, I'm not saying we would, his comment was, I believe one of the appellants said, I want that right to respond.
We'd
even
have
if
to
we
leave
close.
it open for,
I'm not disagreeing with you, yes,
otherwise he couldn't.
okay, so,
I'd like to respond to Ms. McCrory's question about the permit being expired.
yeah, thank you. 1 second if we could, Frank. The only question I have is if you want to get it to him now, and then if he wants to speak to it now, we can be done with this in that sense, because there's not much left in terms of taking in, but I leave that to you. Robin, you want to just wait? Brian?
Yeah, I can't really synthesize this.
So
at the
agree.
moment, But I mean, we could take a 3-minute or 4-minute pause while everyone reads it and thinks about it, so.
Well, I think we have the information. It's Mr. Teekert
Who
who
does?
wants the ability to respond to it. So if he's able to respond to it, we're able to then take that into consideration. Also, the building inspector is here and he's able to make comments. So it would be nice to make progress on this.
I agree. That was my feeling on this. Can we get a copy of this also? Maybe, can somebody forward this to Ms. McCrory and Mr. Teacher? With that, could you then look at this, then we can come back, you can then respond if you want to deal with this? So we don't have to keep this on and open?
What is your email, Ms. McCrory?
Ms. McCrory, is that all right if we do it that way? Or would you rather?
Yeah, I think it's actually a better thing for Mr. Teacher to respond to because he's the one who put the timeline together. So from a detailed response point of view, that's his. We used the timeline to try to make the distinction between all the matters that we were not appealing because we did not have standing to do so or didn't believe we had standing. We were not particularly aggrieved by the violations of the zoning code or the Village of Mamaroneck code. So one of the things that we attempted to do with the timeline was distinguish our particular aggrievement having to do with 2 dwellings or dwelling units on a lot, single family lot, from all the other, we couldn't quite figure out why things weren't working the way the code described them.
Right.
So that's the only distinction I would like to make. But in terms of detail, it was Mr. Teacher doing the foils and getting the responses, and he's the better one to.
Okay. Do you have the email address, whoever has this?
I'll forward it to Stuart right now.
Thank you very much, Frank. I appreciate it. All right. And we can come back to the, okay, and just to finish up, I don't know if did we all conclude then that the appeal now is also with regard to an appeal from the extended permit, right? Is that correct? Let's take a vote on that, please, just so we have a resolution on that. So
I'm sorry, what do you want to take about?
in other words, I just want to formally confirm what we've done in the past, and that is this appeal, we've all agreed, is now also from an appeal from the extended permit, because that wasn't issued, I believe that wasn't appealed from before. According to the appellant, it wasn't issued at the last hearing. But there's no substantive change in it, but it was apparently issued, I believe, just 2 days after it was extended. We discussed this, and I think it was the board, everybody, all 3 board members said, yes, it's an appeal from that. I just want to say, we confirm that. Brian, you're in agreement with that?
It's still an active permit. There's no CO.
I'm just saying, but we're just, so we're allowed, so the appeal is also from the extended permit. Fine. Okay, Robin, you said yes as well to that, correct?
Yes.
Yeah, okay. Brian, yes? Yes.
So my last question is, do you have any questions about standing that you would, I tried to review that. Not a lawyer myself, but
Right.
spent a lot of years.
How far are you from the property line as the crow flies?
As the crow flies, maybe, I don't know, 1,400 square feet or something. I don't know. I haven't tried to do the measure because my reading of the case law is that it's not proximity, that in fact, almost no one would be aggrieved by someone having a front yard that's 6 inches shy. And yet we require variances for that. In these cases, our lots were given different applications of the zoning code than 886. So we have a particular aggrievement. It's not like I was denied a 6-inch variance for the front yard and you got it, that kind of thing.
Okay. All
Is
right.
that,
Well, so then the question is, how specifically were you aggrieved?
I have been prohibited from using my outbuilding as a residence, and I cannot have cooking facilities. If that's allowed at 886, may I put in an application to do those things And will the board rehear or grant that application to allow me to do what 886 Orienta has been permitted to do without a variance? I consider that to be a huge affront to this board.
I don't think this board can tell you what it's going to do on an application that's. not-
Understood, understood.
I think.
Right, well,
You said-
it was my question because Ms. McCrory specifically asked what our questions are and brought up the issue of agreement. So I'm going to be more particular. I understand that disparate outcomes from a code may occur or seem to occur. The specific question here that we're asking you, or at least that I'm asking you, is how did the issuance of this permit to this property harm you, grieve you?
It
This
allowed,
permit, this
it
property.
allowed a resident in the village of Mamaroneck in a one-family district like I am to use their property in a way that I have been prohibited.
Okay.
So this is, for me, it's all about fairness.
But what about the actual harm to you as opposed to someone else? Is there any other particular sense of
If
deprivation that you have? You've talked about as anyone. What I'm asking you is what about for you itself? As your,
my property cannot have a second dwelling. And I can't even use the outbuilding for cooking.
right,
That is a restriction on my property rights. And it's a restriction that's based on code provisions. And it
But
is
the-
unfair to have code provisions applied one way for one property owner who's similarly situated to me or to my property. This isn't really about people, this is about properties.
okay.
Right, well, we're trying to do this on a legal, technical basis, have to. And I absolutely hear what you're saying. But the issuance of this permit to this property did not cause the restriction on your property. The restriction on your property is a code issue and unrelated to the issuance of this permit. I understand the unfairness. I'm trying to determine whether or not the issuance of this permit caused you specifically harm or impacted your property negatively by the issuance of this permit.
That's not the definition of aggrievement. It's quite clear from Sunbright, arbitrary and capricious application of codes and variances is something that the Court of Appeals considers to be within the class of aggrievement.
Right.
So you're suggesting that somehow because this property owner has a second dwelling that they're not permitted to have, I can't be harmed. The harm is the unequal treatment. And that's
I'm-
all I'm claiming the harm is, but that is the
Yeah, I'm
most.
not making,
There's- Yeah, but there's no
I'm
harm
not-
to your property, to you as a resident there. That's
Right.
the question I believe that we're asking.
What is harm to my property? I don't quite, I mean,
Well, it's
if
harm to you as a resident there. If my neighbor
My
was to build
development
a new
rights-
facility, I might say this bothers me.
someone else's development rights don't change my development rights, but we're both supposed to have the same development rights in the same zoning district.
So aside from, is there anything other than what you just stated, which is that aggrieved your, or that impacted you and your property or use of your property? Because you can't do that because you,
It is the unequal application of the code
okay,
that for me has represented a property right restriction, which I believe is one of the most fundamental constitutional rights.
Now, I'll ask you this, when I looked at this, I mean, are you maintaining that they're having two dwellings here?
Absolutely.
But their application, I believe, in the papers I read, and they were voluminous, but I went through them and they talked about on the zoning on one of the applications, they had a sequel that indicated it was no zoning change, that they're a single family dwelling. So if that's the case, I guess they're saying, and some of the indicates, this is accessory.
Well, that's the guise, isn't it?
Well,
So my outbuilding was allowed to be accessory, but not a principal dwelling. A dwelling is a principal use. So the definition of principal and accessory goes with zoning classes.
well,
You
accessory,
can have an accessory dwelling if you have a school or a club. You cannot have an accessory dwelling in a one-family district. If you have two dwellings, that's a two-family lot.
but the applications, as I read them in the files, and the history of this was that they refer to this, and I believe even in the plans, as an accessory. An accessory is defined in the code. I believe 342.3 is for the use of the building, a portion thereof, which is customarily incidental and subordinate to the principal use of the land or building located on the same lot.
And the principal use
use
on that lot is dwelling,
Right. So
no more than one.
right. So if somebody has, a pool house, something else on there that's not a dwelling.
It is a dwelling. A dwelling is something that has, dwelling is very clearly defined. And this is a dwelling, a single family dwelling. So dwelling is very clearly defined. I believe the reason my outbuilding was not allowed to have a stove or to be used as a residence was because that would make it a dwelling and would make my lot a two-dwelling lot. And it couldn't be any clearer in the code that you're not allowed to have two dwellings on a lot. So with
Where are you
all,
getting the definition I'm dwelling from? Is it 342 or what? Could you tell me?
it's in the 342-3, I believe.
Dwelling is defined as a building designed or used exclusively as living quarters of one or more families. That's it. And then it shall not include trailer, home, tourist home, rooming house. So that if this is designed or used exclusively of living quarters of one or more families, then it is a dwelling, whether or not it is the principal dwelling, a secondary dwelling, a third dwelling, or some other thing. It is a dwelling.
Okay.
And the term dwelling is also defined in the building code. So, and you did that, did an extensive review of that for 130 Beach Avenue and said that that third floor was a dwelling unit, even though it didn't have a stove or cooking facilities. So what I'm bringing to you is
Oh, so you're saying that we had done that on another matter, right?
Mr. T-Bird-Smith.
Right, so that's the, okay. That's
Yeah, so, I guess what I'm saying is
administrative, I guess, yeah, okay.
only you can remedy, two of these decisions are zoning board decisions. Only you can make sense of them so that people understand what the code means and it gets interpreted consistently going forward. If it means that there can be two dwellings on a lot, I would like to be able to use my outbuilding. I'd like to be able to put cooking facilities in there and use it as a residence.
The difference being that this was a pre-existing structure that was there, has been there for a long time and can continue to be there. It had a bedroom, it had a kitchen. It's simply the continuation of that use.
That isn't a difference because that was true for my outbuilding was the original house on this lot. And it had all of those facilities as well.
I have a question for the building inspector, since he just said this was pre-existing. Are you saying that because this is do you have evidence that this pre-existing, you're saying there was a pre-existing use of a second house, And so then my question for you is, was this pre-existing house and use as a separate dwelling in use prior to the date as the zoning code was adopted, which made this a single-family district?
So I can only answer that by saying I walked through that structure before they even built the 886 house to see what was in there. And it was old and dilapidated. It hadn't been used for years, but it had a kitchen. It had a bedroom. It had, it was a mishmash of a space. It had a garage at that time, but it was a pre-existing used building, for those purposes.
Well, then if that was a
Isn't-
pre-existing
and-
dwelling,
Right, then doesn't that fall under 342, 63, and 64?
Yes.
no. If that was a pre-existing dwelling, why wasn't that the dwelling in the new house they built a second home?
That
They
was my,
demolished the building.
that was
I don't
my thought.
understand. If you had, did they either had, and I don't know the situation, they either had, if we're talking specifics now here, they either had one of two situations. Prior to this permit being issued, there was either on this premises one single family house and only one house with a second building that wasn't used as a residence, or there were two separate residential buildings, two separate dwelling units. If there were two separate dwelling units, then that would have only been allowed to continue if the second dwelling, whichever the second dwelling unit is, was erected and lived in and used continuously since before the zoning resolution was adopted that made the second single family use a non-conform, before the zoning code was adopted that made this a single family district. If the building that you said was used as a residence was in existence and used as a single family residence since whenever this building, the original building. However, now that the original building was demolished, then it falls under the section of the code which says that when a non-conforming use is demolished, it ceases to be allowed. That would mean that they shouldn't have gotten a building permit for the first house, for the new house, because they already had a secondary house. The question goes, because I think this whole question goes to much more complicated question. And
Robin, you're not even considering the fact that the property was subdivided.
Exactly.
right, I'm just, if we have a, right.
So
that's a
there was
total-
no continuation of use.
So there was a
Well, plus
totally
there- plus
different
if
issue.
it's vacant.
The bottom line is, there's either two single family uses here, or or not. If there are two single family uses, they can only exist if one was there when prior to this becoming a single family district. If it was erected then and was in existence and continued use, if it stopped being used for more than 6 months, that non-conforming condition lapsed. Since
Right.
you said, Frank, that it was in a deteriorated condition, that presumably means it was not being used for at least 6 months. Therefore, that this second home existence lapsed and they could only have one home. Whether that one home is this unit that we're discussing or the main building that was rebuilt, I don't know. But it strikes me that's where we have to come down. That's the question we're looking at. I'm leaving aside some other issues related to the actual appeal. I'm now going to the specific, to the actual substance of this, which seems to me, sorry, I have to plug in my computer because running out of power. So you'll have to give me a second. I have to go down and plug in my computer or I won't be here anymore. But I think that's the principal issue that has to be dealt with, or the underlying bottom line issue.
Well, Robin, well, I don't know if you can hear me, so I'll wait.
So, Mr. Chairman, to
Okay.
address,
Well,
I got it.
hold on.
Yeah,
I got it.
Robin, so yes, that is the substance of, of the appeal, as to whether or not the building permit was issued correctly or incorrectly. But we actually have two issues here. We have the standing of the applicants, which is a technical legal issue that would give us the ability to make the determination as to whether or not the building permit was or was not issued correctly. And there really are a lot of issues there. It was a subdivided property. One house was removed, so you now have a new plot, and the only thing there was this accessory building. Yeah, that's the substance. But the question that we have before us, which I think we have to answer first, which we're not even at our deliberations yet, is whether or not the applicants have standing to appeal the issue, to let us speak to that.
I agree. I
So
agree.
it's still
We
an
were discussing the
informational gather.
substance. We didn't deal with the first question of whether they have standing to file this. And I
No, because the
absolutely-
reason we didn't, the
But
reason.
we're also not supposed to be deliberating
I know, but we
right
started,
now.
because the building inspector started talking about the substance, Ms. McCrory started talking about the substance rather than the specifics of the actual, what
Of
we
the
have to discuss
standing.
first, which
No,
is
but,
whether.
but we had
somebody has
also
standing.
excuse me, but we had also discussed at the beginning, and we've done this with others, that standing is within the context of what occurred and what the overall is. So we did, and at the very beginning, and we've done this with many others. Occasionally, we've had a special thing, we're just on a, treated one as a motion, but on this one, we've said to know standing, you have to know the whole thing. You have to understand what it is. And that, I think we have that now. What,
May I address
I
that?
I have a question on one thing here, for the building inspector. Is this, I noticed that it's called an accessory building on the plans. And some of the papers indicate it's in a single family dwelling, in a single family unit, they don't need a variance. Is an accessory building capable of being a primary or being a residence? Or let me withdraw that. If it's an accessory building that's not used as a residence, as a separate residence, but part of the main residence, is that permissible?
So it's been called both the pool house and an accessory structure in all of the paperwork. I think the intent was always to be a pool house.
But a pool house would require a variance, wouldn't it? Isn't there a maximum amount of size on a pool house under the code?
Not even mentioned in the code.
Yes.
Yeah, I think it is. I think it's mentioned, isn't it?
Yeah.
No. I don't think,
Excuse me, Ms. McCrory.
I'm sorry.
Thank you. Frank,
I think it's 21. 21. There are dimensions, height and square footage for an accessory structure. But again, they didn't expand the structure that was there. It's basically the same building that was there. They renovated it, obviously inside and out, but they didn't expand it at all.
okay, well, cabana is what it refers to, right? And the cabana is a non-residential structure of under 200 feet. All right, so that doesn't give us any guidance. All right. Okay, very good.
So the question that I have is,
Who's this, Ms. McCrory or just one?
no,
Let's
I
focus.
I have a question about the information that we need and how we are to proceed. Are we going to proceed by closing the meeting at some point? Perhaps not tonight, because Mr. Teekert needs time to review the new email correspondence. But are we going to close in terms of getting enough information to determine whether or not the applicants have standing? And then would we be able to keep it open for gathering more information as to whether or not the substance of the permit, if we get to that far? I mean, how do we do this procedurally? Or do we have to get all of our information now on both subjects?
I think that we had decided at the beginning, and council had confirmed as well, and we've done this in the past, we were going to take the hearing on everything and then grapple with the issue and make decision on the standing, on the statute of limitations. And if it go, and then we would either say, okay, that ends it, or we would then deal with the subject. I think we have all the information on, at this point, I do at least, but maybe I'm completely, I leave that to you for your
Well,
standpoint.
no, I'm happy then that the building inspector did in fact address
Yeah,
the rationale for the permit, the fact that I can see from the paperwork that the permit, the application for the work was to renovate, renovate and interior and exterior, and that the structure did in fact have a kitchen, already. And this did go before, and then based on that, I think, Frank, you sent this to the BAR, correct?
That's correct, and they commented on it. They talked about the use of that building.
Right,
Frank?
so,
Yes, sir, go ahead.
yeah, so the applicant did in fact bring this up and have plans showing the work that wanted to be done.
That's correct.
Frank, when you went through this before they did any work,
Yeah,
was it habitable?
no,
So there was no real bedrooms or kitchens at that time that were of any use. They weren't being able to be
well, they
utilized.
were there, but like I said, there was just a dilapidated building.
Right. Okay.
If we're going to, and I didn't remember, somehow I thought didn't remember that we had decided we were going to hear the whole thing.
Yeah.
And not just discuss on standing and statute of limitations issue first. But because I don't think the actual the property owner has actually responded to the substance of this. I think they've only responded to the standing and statute of limitations issue, because I thought that's what we were addressing first. If I'm wrong, then we're going to need to give them the opportunity.
We
respond.
shall, but I will point out
That's-
to you, Robin, I will point out to you at the last meeting, I asked the owner's counsel about the building and questioned about it, and he declined to respond. I mean, you can check that on the video. I'm sure it was there. But it was because I asked that. I said, well, what is it used in, et cetera, and there was no real response to that. I think it's apparent that it is what it is. It's the two purposes, but they'll come up, and I'm sure they're going to speak now. Is there anything else we have at this point before we take the next, which I guess it would be the owner?
I just would like to
Well,
make, I'm
Yeah,
sorry.
please, Ms. McCrory. go
Okay,
ahead.
now I do have one other question. We've asked Ms. McCrory specifically what the agreements were. And I think that we also need to ask Mr. Teekert to see whether or not there's any other information. I don't know whether or not his connection is still on, but he's also an applicant, and he should be asked what his agreements are.
Agreements, you mean?
Agreements.
I'm sorry.
Yeah.
Thank you, Brian. I apologize.
Yes, I think Ms. McCrory stated my agreements correctly. For the past 3 years, I have been defending against an prosecution that because I had a space where a stove could be, that qualified my third floor as a
Dwelling unit.
dwelling unit. In the case of 886 Orienta, there's a stove, an actual stove. And just to the point about what pre-existed, on April 18th, after a lengthy exchange with Mr. Cavalacci about what was in the what's now being called pool house, he said, although I could not find a drawing of pool house, it was on the original tax card of a I think probably as a 1,287 square foot 4-car garage, originally built in 1887, with an apartment over the garage. I believe that's entirely correct. He then went on to say, this verifies what I saw in 2016 walking through the structure with remnants of sink plumbing on the second floor. There was also laundry plumbing behind the garage. I don't think anything's ever been offered to indicate there was ever a kitchen in that structure. So I mean, as I said, I've heard the arguments for a very long time in front of the zoning board about what constitutes a dwelling unit, and my agreements are the same as Ms. McCrory's. I've been not denied even, thinking about having a stove.
Frank, thank you. Thank you, Mr.
Mr.
Right.
Cavalacci, did you see a kitchen when you went through the structure?
I saw the remnants of the kitchen. Like I said, it was very dilapidated, but I could see the plumbing. And there is a plan. The architect who drew the pool house had the not only the proposed what they were going to do with the structure, but what was there before. So there is a layout of a kitchen, and there is a layout of a bedroom area on that plan, and it's part of the record.
Yeah, I did see that, but I think that Mr. Teekert is calling that into question as to,
The original plans.
whether or not that's something that was historically filed or whether or not that's a creative illustration, a recreation.
Right.
Am I correct with that, Mr. Teekert?
I would completely concur with that. I don't think writing on a set of plans, existing kitchen, qualifies as proof there was a kitchen, especially when, other than that, the only statement we have is remnants of sink plumbing. Would have been a sink.
Okay,
Frank, I have a question for you, if I could, please, and that is,
Nothing else.
okay. Frank, is this, I know this, and I saw it's on the plans and everything. This is deemed it's listed as an accessory. Is this an accessory building?
As it is now, what they've built, they're
Yeah.
building it as a pool house.
Okay, so it's not a habitable dwelling? That's not what can it be used as a separate dwelling?
I don't believe that they're gonna have tenants in there. I don't believe they're gonna be charging rent for people to live there as a habitable dwelling unit. I think it's a pool house. That's
Well,
what-
wait a minute.
Yeah, it's two different things.
Yeah, whether they charge rent, whether a third person lives there, whether anyone else lives there is not relevant. The question is only, and you don't know that. And the question is only whether whether this satisfies the conditions of a dwelling unit. And from what I've understood from you've said, it has bedrooms, it has a kitchen, including a stove, which we may or may not all agree that a stove is necessary, but it has a kitchen and it has bedrooms. Therefore, it would seem to satisfy the definition of dwelling in that someone, whether it's the daughter, son, parent, husband, or wife of the principal residence could live there, or whether a third party could is irrelevant. Does it have all the requirements of a dwelling? I think you said, basically your description says yes.
Well, it does match the description of a dwelling unit in that.
Okay, that's, yeah.
Now, does that mean from your standpoint, so I understand you, a dwelling is a dwelling, I guess defined as a dwelling, one dwelling unit only. Is it permissible to use this as a dwelling?
Not in a single family zone, no.
And this is in a single family zone, right?
It is.
Right. So just so I'm trying to understand this. So it's an accessory building. You mentioned a pool, but it's not permissible to use it as a dwelling. Is that right? I don't want to mischaracterize or misunderstand you. I think you're being very forthright and helpful. So thank you.
so then.
No, Frank, can I answer that? I'm sorry.
Oh, I'm sorry.
Yes.
So it leads to another question. What component is vital for it to be a
Brian,
dwelling.
can we
Yeah.
not go there? We had an entire
Yeah.
case. In fact, Mr. Teekert filed an appeal of something that the building department issued 2 or 3 years ago. And we had a months-long matter before the ZBA, and the ZBA reached a determination as to what was and what was not a
Okay.
dwelling unit.
Yeah.
And so I don't think it's appropriate
Okay,
right now
so-
to ask because I don't want to get started down
Right,
that.
yeah, we've already done that. Plus we have defined terms and the building department's been very
Okay.
helpful. Okay,
But to Brian's point, if you went by that last case, we could just take the stove out and then everything would be fine with this building. Is that correct?
Well, I don't know.
That's
That-
what the board
I don't know that,
apparently decided.
And we took a stove out and everything was hunky-dory.
except this is a separate building. And then the question comes up, what is it? What is it accessory
Pool
to?
house, Mr.
I
Chairman.
understand. Okay,
Pool houses don't need bedrooms, I don't believe. I've never had a pool.
Well, hold it,
you had a bedroom.
I've had that.
hold it. Whether you have a bedroom or
Let's
not,
let's move along.
somebody could have a pull-out couch. Nobody removed Miss McCrory's structure. It's, you know, and if you go back to the case from her property all those years ago, it also went towards the kitchen facility. So I think Robin is correct, that it's been discussed and that we have our definitions. And
Okay,
we can go from there. Right
Right.
now, I think we've gotten a lot of very good information on what's currently there, what it could be considered, and what the situation is with the property
okay,
in terms of development overall. So
okay.
I'm
I
pretty
think it's-
satisfied with the information that I have.
Thank you.
Actually, we don't have a lot of information. We have a lot of information about what is existing there now. We have no information about the historic use or anything like that, although presumably, even if they had a non-conforming use, if it was.
It wouldn't matter. I think you've covered that before, Robin. We'll deal with that, but
Robin, there was a subdivision.
it was.
That was the only structure left in between both properties at one point. I believe that I have enough information about the history. However, that being said, I believe that the Sigalows have the opportunity, and they should be afforded the opportunity to respond to all of this.
Well, of
Of
course,
course,
of course.
we have
So
to.
if they want to, if they
And they're
they would
waiting
like-
as soon as so let's proceed
if
with
they
them,
would like to give us historical information, that's their choice.
obviously. And I think, yeah. So I think we should turn to them now because it is now 9:04. We have 3 long hearings in front of us and we have some other matters to address. So.
Mr. Chair, just
uh,
quickly, may I just
Corey,
say,
you have one more quick thing. Go ahead, please.
I just want to explain what the accessory uses in a one-family district include in terms of buildings. Garden houses, tool,
Where are you getting this from? The code?
342,
Okay, go ahead.
21,
Yep.
B3.
Okay,
Garden houses, tool houses,
yeah, thank you.
playhouses, greenhouses, or
Okay.
other uses customarily incidental to the
Right, I'm
resident.
aware of that. Yes, okay. so the-
Okay,
And
and
that's 340, just for the record, it's 342.
21.
21B3.
B3. Okay, thank you, Ms. McCarr, appreciate that. Okay. Does anyone else want to speak to this? Does the homeowner want to speak to the property owner?
I have the lawyer for the homeowner.
Certainly, go right ahead. Please, if we could just be to the point on this thing and not, we've received your second letter. And if you could just please be kind
The
enough. to-
homeowner wants to speak, just make sure you raise your hand, please. Okay, everyone's getting.
Good evening.
Mr. Wexstein seems to be muted.
Mr. Webster, who wants to speak? Who's speaking now, please? Ms.
Actually,
Blau?
I'm Jessica Sigalo. I'm the property owner.
Yes.
My lawyer, Adam, was going to speak first.
Okay,
Hi, do you have me now?
we do.
I apologize. I was born too early for technology.
Okay,
At this point, I want to bring this back. This simply is a case where the applicant has not established that your board even has jurisdiction to hear this. They're not aggrieved. I know you asked me to keep it short, but I listened to an hour and a half of Ms. McCrory and Mr. Tickert last week at last month's meeting, July, and over an hour tonight. So I'd like to just take a couple minutes here.
take 2 minutes with pleasure.
Well, I'd like more than two. I used the wrong language.
Following with you, sir, trying to be. Go ahead.
The burden is on the applicants to show they're aggrieved. That's clear. All a standing case law shows that. The only claim they have made, and they've said it tonight, is essentially they think that a subsequent determination was unfair to them. They've been treated unfairly, it's unjust, and therefore they've been caused injury. Well, that's just not the kind of injury that New York law recognizes.
You've addressed that in your letter, I believe, right?
I did, and if you just give me a few minutes, I would very
Go
much
ahead.
appreciate it.
Please.
Because there were things said tonight that go to this. There is no causal relationship between this permit and what the applicants are unhappy about. And I will say that I've done diligent research on this. There is not a single case in the history of New York that has held a feeling that another permit was treated, another applicant was treated better than you after the fact gives you standing or counts as aggrievement.
Okay.
Ms. McCrory frankly said she's not a lawyer. She writes very well, by the way, but she's not a lawyer. She keeps citing the Sunbright case. She takes a little bit of language that's favorable to her and says that gives her aggrievement.
Well,
What
lawyers
that
do
case-
that all the time.
Pardon? They do, but I'm not doing that tonight. What
Okay,
that
I'm
case
not
is about.
suggesting that, but that's not that's a critical comment.
I said, she writes well, but either she doesn't understand or she's misleading the board.
Well,
Because with that case.
Excuse me. I know that you're doing a fine job for your client and you're trying to, but please, we're going to maintain civility here. I don't want to hear that she's misleading in this. If there's specific things, you can point them out, but let's
Okay.
characterize them. That doesn't that doesn't help any of us.
You are correct. I apologize.
No, it's okay. Thank you.
The Sunbright case was a case where a neighboring property owner, gas station,
Mhm.
to a proposed car wash, sued. The issue was whether the fact that they were right next door to the other use was sufficient to give them automatic standing.
Mhm.
It didn't involve a property that's 0.7 miles away by walking distance or one that's 2 miles away as the crow flies in Mr. Tickert's case. What that court found was it can sometimes show injury, but it doesn't put you within the zone of interest that's protected. So in other words, under zoning, that would be the value of a property, parking, visual, air, all those things. And in this case, they held that the plaintiff in the case, which was another business, their only injury was increased business competition. So they didn't have standing. But neither Mr. Tickert, or Ms. McCrory can claim that they have standing because they're right next to this, or that they have standing because they're within 1,000 feet of this, or that they have standing because they're within 1,500 feet of it. I think if you look at the exhibits, even Ms. McCrory is a lot farther than that. And in fact, what the Sunbright case says is we recognize that permitting everyone to seek review could be work against the welfare of the community by proliferating litigation and unduly delaying final dispositions, which is exactly what's happening here. The fact is that the real claim at this point is they were treated unfairly. And in their submission, they say it's a violation of equal protection. Well, that's nice, but that kind of constitutional issue doesn't belong before your board. And the case law I cited shows is clearly not within your jurisdiction, which should really be the end of the story on this one. The other thing I'll say is, in trying to make her case, the applicant said, "You're the only one that can remedy our problem." Well, what does that mean? To me, it means that if you're aggrieved, if you grant the relief that is sought, you've given the person something. Here, you're not doing anything for their property. All you're doing is penalizing another property owner. It doesn't give them the right to do anything. It doesn't improve their situation. It doesn't eliminate an impact on them. This is exactly why they're not aggrieved.
I have a
And
question for you on that.
yes,
If I, two questions. One is, if I live in a single family zone that I like because I don't want multifamilies, that's what I elected to live by. And somebody next door to me gets a permit of that, I'm not saying like this, but a permit that allows two family when it's only zone one. I assume you would, I would be aggrieved as the neighbor to say that would impact me?
I think there's a very high likelihood of that because you would have a
Fine, okay.
presumption,
I'm with
you would have a presumption of injury. And I think in most cases, you could show you're within the zone of interest.
Right. That was my second
But-
question.
I'm sorry.
My question, so it's a matter of distance to it at that point. I see, isn't there an impact? And this is a question I have, isn't there, or is there an impact from the fact that the character, I guess my concern is, what if 10 people in a adjacent or contiguous area decided they were all going to do something that was a violation of the code, and someone adjacent to that then challenged it, but they couldn't get, they were too far from some of the people in the middle. I mean, can you not create a de facto change by, if everyone did it and nobody challenged it?
Well, I don't think that's a hypothetical we have here, but I would
No,
say
I'm not,
to
I'm
you,
not saying that.
I would say to you, if you look at the maps we put in as exhibits, there are probably 20 or 25 homes right in the immediate vicinity of this property. And that is the issue. It's not saying no one can change it. If there's no one in the world who can challenge it because they don't have particularized injury, we might be having a different discussion because
Right.
there is
All right.
case law
Yeah.
that
there-
suggests that.
Mhm.
But here there are people, and Mr. Tickert and Mrs. McCrory are not those people. If you give these folks standing agreement, whatever you want to call it, then anyone in the village of Mamaroneck who thinks that their house has been treated differently than an application that's pending before you will be able to appeal
Well,
to your board.
right.
And you're opening up the door.
No, I understand you. She's also not an attorney, but I understand you. Your point's well taken. I understand.
Now, just to get specific as to things she said, and number one, on timing, I just want to make sure that by amending this, the board isn't making any kind of concession that the timing issue that's out there is relieved because there was a renewal of the permit. The law is very clear that if a permit's renewed on the same terms, it doesn't start a new statute of limitations.
Well, you'll send us a letter with that case or something. I mean, we
Well-
haven't addressed that. It is what it is.
I'm hoping I don't have to send you a letter because I think
Okay, well,
that-
it
I
is
think-
what it is.
I
I mean, that's
think
all I'm
we
saying.
would
We're
like-
not deliberating now, so it's like,
Well, I would ask that you do, because there's one issue that's threshold. And you're talking about stuff like Mr. Tavlachi's email, and unless he's talking about aggrievement in his legal opinion, it's not relevant to the issue that should decide this case.
sir, I've been on the board a long time, as have many other people, and I would say that it is a custom of boards, particularly local boards, to often hear items that may not be the most relevant. But it is the way
I understand.
these are.
And it's your decision. You're the chairman of the board, and I wasn't suggesting you should have not summarily gotten rid of it, but I would suggest that my property owner has now sat for two hearings, paid me a lot of money to oppose what we think is a frivolous application, and will have to continue to do that in an application that they didn't bring that's hurting them disproportionately on a building that's complete, by the way. And what you see here is the applicants keep throwing more and more up against the wall. They gave you a 62-page chronology where they kept accusing my clients of doing, go ahead.
Yeah, let's stay specific and not say the thing.
Okay.
Well, they
Okay.
are what they are. Please, I'm not trying to inhibit you in any way, shape, or form, but I just don't want people attacking each other. We're all on the same team. You're all members of this community. And I don't want this to come.
Right.
I won't go
like to-
down that
You've been
road.
very-
but
And
with
I
all-
appreciate you doing that tonight. And you've been
I
very.
won't go down that road, but with all due respect, they've relied on it in writing and orally as part of their presentation.
Right, Mr. Wexton, I would like to just go back just a touch. The issue of the original permit and the expiration date. I would like that addressed by you as to whether or not the permit had expired.
My
Whether or not-
understanding was it did in May of 22, not May of 21. And when I spoke to your board last time, I was misinformed. What happened, as I understand it, is there were two permits, one for the pool, one for the pool house. One had expired, the other hadn't, and my client thought the architect had renewed it. So as soon as they learned, as soon as it was brought up, they checked and they remedied the situation.
Which
If
one had
you have
expired?
Case law.
The
about
house,
extension, could
The
you
pool
with
house, you said?
respect to
yes.
the expiration date, and the renewal of a permit on the same basis, if you would circulate that, whether as a memo or just circulating. the
Yes.
case, that would be
I will
fantastic.
do that.
Okay, go ahead, please.
At this point, I don't think I really have more other than on the timing. Final point on the timing, there's an awful lot made about when FOIL requests came out, what they showed. There's some ambiguity, but again, that's one of those issues that's somewhat of a red herring because I think we established last time, I won't go into it again, that there was constructive notice of this over a year in advance of when the application was made. Now, I believe my client, well, I'll leave it to her. I know she's on board. I'll leave it to her whether she would like to address the board. I'm also happy to answer any questions, though I'm sure you'd like to be rid of me.
Well, I do have another question. And listen, these sessions are here to gather information so that we have what we need when we make our deliberations. And what was brought up earlier in this evening is the history of the structure, whether or not the structure was in use at any time proximate to when the permit was asked for, whether or not it actually had a full kitchen, whether or not you have evidence of that. And also, well, I think we have, I mean, unless you have something which contradicts the chronology of the subdivision and the building of the primary residence, any information that you feel necessary to submit, you have the opportunity to do so. So I'm asking whether or not you would have any more information to submit.
We do not intend to submit anything. We believe that this case is so clear that any objective third party would not think that the merits of the complaint should be reached. I can't in good conscience have my clients go down a road that is not an efficient one.
Okay.
So what you are saying is, by case being so clear, you're strictly focusing on the standing issues.
And timing,
And time.
both of them.
Right. The standing and the timing issues, not the
Correct.
substance of, okay.
That's
Yeah,
Thank
correct.
you.
I think you said the same thing the last meeting. Thank you.
You are correct, exactly.
Okay. Thank you. Did you want your client to speak? Does she want to speak, please, by all means? Ms. Sigler?
I don't know, Jeff,
Dear Chairman Neufeld and members of the zoning board, Board of Appeals, I prepared a speech. mostly, you know, to counteract some of the, you know, complete false, malicious, and irrelevant statements that Susan McCrory and Stuart Teekert have put about me and my family and the property. I am choosing not to go down that because it seems like that's not productive. But, you know, there's just their 92-page document references the Declaration of Independence, and an inflammatory section they labeled a controversy. So, you know, I'm trying to rise above that. They didn't. And there's just multiple instances throughout the chronology and things that they wrote about that are wrong, that are incorrect. And, you know, they've been given a lot more time to respond to questions, and have acted like they're the experts on our property and the zoning laws. You know, and so I just would like to make sure that it's clear that, you know, if there's questions that you have for me and for my property, I'm happy to answer them. You know, I'm trying to be cognizant of the comments you've made and to be respectful. You know, being brought into something that is very not, I'm not something familiar with, and is just overwhelming, and has caused my family, you know, my husband and I, just sleepless nights, a lot of anxiety, a lot of costs, and seems to be that it's just going to keep continuing. And it's just, it's horrible that we've been, you know, brought into this, and in the middle of something that feels like is not even our, you know, it's not our fight. And we've been dragged into this, and we've just been painted as repeat offenders, and that's not the case at all.
Ms. Ziegler, well, thank you for your comments, but I would just point out, no one's attempted to limit you or your submissions. Your lawyers made them, and lengthy. And actually, my only criticism of these submissions, sir, the font's a little small on them. But
I'm wearing these
I mean,
now.
I don't think this is a malicious thing. I think this is a difference. It happens in communities. It happens in families. It happens with strangers. So you don't have to, I'm sorry. I would urge you, just, you know, you've made your presentation. No one's tried to limit you. No one's tried to take anything away. Your lawyers made 2 substantive, lengthy submissions and spoken twice. And if there's anything else you want to add, by all means, but as long as it's relevant and stays with the issues.
If the board isn't willing to close the public hearing, would it close the hearing just subject to allowing comments on Mr. Tavlacci's memo? Because you've gotten an awful lot of information.
Okay, that's it. I hear you. I think that, you know, I think that's it's an interesting question, and I think that we have taken a lot. Has Mr. Tickett had a chance to read that memo, that email? Mr. Tickett, are you there? Ms. McCrory, are you there?
I am here. Yes.
Okay.
I don't-
Does he want an opportunity to respond? See, if we close it, the applicant has noted we could close it subject to giving Mr. Tickett an opportunity to, I would say, submit a written response to that. Not to anything else, but to that.
I would like that opportunity.
Okay. And the applicant has agreed to that and actually suggested that, which I think is an interesting, I think.
The property owner, not the applicant.
I'm sorry, the property owners. Yeah, you're right.
I would like to make that motion.
Okay, well, before we do that, is there anyone else who wants to
Oh,
be?
and subject to getting a copy of the case that Mr. Weckstein referred to with respect to the
Well-
status of a renewal permit.
Yes, I would go past that, Robin, but before we do, is there anyone else who wants to speak to this application? Anyone here? Anyone not here who wants to speak to it and arrive here? Okay. I hear no one. Is that correct, Brittany? There is no one waiting?
Nobody.
Okay, so Robin, what I would suggest is exactly to follow what you were saying, is to close it subject to 2 things. Factually, to allow a written response to that one memo, as the owner has acknowledged and said that would be an idea, and I think that's fine. And also, I think both parties can have a day certain to submit legal cases which would include the one he mentioned, since those are not factual matters, I'll ask counsel, but somebody wants to, they both want to submit, I want back and forth on a certain day, let's say in 1 week, legal cases that they may have that they want us to look at. I don't think that's a problem, but Mr. Charlie,
Sure, that sounds fine. I mean, we could do what we want, David. I don't think this is something we need Charlie's view on.
okay, I'm with you.
We can
Charlie,
do
if we're
what
messing
we
up, you
want.
scream right now.
So David, let me finish. So I think
Please.
that I'm okay with that, but not memos, just case law. Cases, because once you get memos.
How about this? 2-page max or a 3-page max,
Fine,
because they may want to say this case deals with such and such. I don't want to get into
fine.
a,
That's okay. I just don't want
is that all right?
to.
Okay, so what do you think?
See, I don't think that's closing the hearing at that point. So I'll ask you to close the whole thing. I just don't understand.
Okay, so wait a
You're either
second.
closing it or you're not.
No, we.
You asked me, you don't understand, so let me try to either learn from you or maybe explain. What I'm saying is that you want to put a case in, right?
No,
Oh, you're not, oh, okay, I'm sorry. Okay, I thought you
I
did.
haven't asked to do that. I'm finished. other
Robin,
than-
Robin, wasn't you asked for the extension case?
He
If-
didn't say, he didn't ask to submit it. He said there is a case that specifically says that.
Okay, but he hasn't given, if you want us to consider that,
Sending it to us.
if
he's
you
not
want us to,
interested in sending it to us, Dave, then I don't think we need to ask him for it. He doesn't want to send it to us.
I'm
Then we
with you,
can
I'm
just-
with you, yeah.
Then we can just leave it open for Mr.
That's-
Speaker to respond to that it's not a memo, it's an email, to respond to that, that the email
Fine,
dated, whatever it was, August 15th from the building inspector, and he has not more than a week to do that.
okay, why don't we just say by 1 week from today, next Thursday, by the close of business, next Thursday at 5 o'clock. Robin, do you want to allow them to submit a page or two of any cases they want?
No, if that's it, I'm okay with just having them do that. I know they submitted references to cases already, and I don't know that we need any more.
Okay.
Charlie, did you have something? I noticed it's not up to me, but Charlie had his hand up.
Yeah, please, Charlie.
I was just saying, so, when the amended permit issue came up, I had that flagged as something to look into.
Okay.
And I do know the line of cases that deal with that. So,
Yeah, well, that's for our deliberation then.
correct.
Right, we look at, we can look at cases, we can do our own research, that's fine. All right, so there's a
I would
motion,
move,
just to clear.
so I
let's-
make a motion that the hearing be closed, subject to allowing Mr. Teekert and or Ms. McCrory, whichever one, and or Ms. McCrory to submit a response to that email sent by the building inspector within not on or before next Thursday. Which
At
is
5 PM, okay. Brian, is there a second on that?
I want to make sure that we do have the case law. Charlie, you'll be able to provide
He'll provide it.
what we just discussed.
Yes,
If it exists, you will provide it.
All
Okay.
right, so then I'm in agreement as long as.
Is that a second?
It's a second, yes.
Okay. Okay, Robin?
yes.
Okay, Brian?
Yes.
And I vote yes. Thank you very much, and I appreciate everyone's efforts, and thank you for the time.
Thank you for your courtesy and attention. It's appreciated.
Okay, thank you.
Thank you.
Thank you. Have a good evening. Okay. All right. Does anyone want a 4-minute break or not? We'll just move right on.
I'll
Okay,
take a 5-minute break.
And Dave, when we come back, perhaps you can consider, we do have a resolution.
and yes.
Right, instead of going to brand new things, if we could just handle that resolution first and then we can
That
go
is
to the
the
brand. new.
resolution on 690, is that the one?
Yeah, it's the bagel place.
Okay. Pumpernickel?
If you like, I hear.
Yeah, everything, pumpernickel, I don't know. We'll let Frank pick. Okay, very good. We will take, I'll put the timer on. We will take 5 minutes. It is now 9:30. We'll see you at 9:35. 5-minute timer.
5 minutes, counting down.
Hey, Brian, thanks for reminding me on that 690.
Yeah, I mean, there is
No, I agree.
one issue we have to discuss on it,
Do
but
we need to, before we start, do we need to officially say we're back or something?
Yes, we're back, Robin. I don't know.
I don't know what
No,
the
I don't know.
protocol is, but it just
We-
strikes me that
Yeah,
we need to make it clear to the public that we're starting again.
and I guess we gotta unelevate the last people, right?
Right, Sue and,
And own herself.
Brittany, are you there?
Yeah, I'm de-promoting them.
Okay, and we're back live, right?
You can
Yes.
tell us, you can say
Okay.
that. Okay. So the matter we have now is the resolution. We're gonna just get one in here in 690 Mammo Bagel Corp. I guess it was the question, the type of restaurant at all on that? I'm looking at my notes here.
you know, we have this come up a lot, but the question that I have is, does it matter? We have
No.
spent
Yes.
a
Yes and
lot
no.
of time on this board agonizing over whether something is one thing or another. Unless we need to, I don't know that we have to.
Robin, my answer is yes and no. We spent a lot of time agonizing and no, it doesn't matter.
Then
Well,
let's not,
I
then let's
concur with you. I don't know, but Brian. go ahead.
Hold on. Some of the definitions may impact its placement near other places and so on and
Right.
so forth. I don't know that that's the case here, but honestly, I think this is a pretty simple one. The question is, you know, do they have a menu where they're cooking food? Is there waiter service? And I think the answer to that is no. It's strictly bagels and coffee and prepackaged things, or you know, like you want to buy cream cheese or lox or milk. You know, if that's the case, then I would say the seating is accessory, and that would make it a carryout.
But it is 20. Question is though, what if can they change?
The problem, I think, is that
They
our.
can't
as we've
change.
as we've discussed multiple times, and Brian, this may have been before you were on the board, but in the many years I've been on the board and Dave has been on the board, we have recognized the problem that our village code definitions of restaurant do not accurately reflect what the true, you know, how codes, how you read restaurant uses as they exist today, and there's a lot.
Okay,
of,
so I'll give you a quick read in terms of my history. I have watched those. I've seen them go back and forth. I
Right.
think that it was an absolute abject waste of time, because in my mind, you have the ability to narrow down what it does and what it does not. This is not a brew pub. It's not a restaurant. So it only comes down to carry out and fast food. So once you get down to that, you ask a couple of simple questions and you just go with the best one. You're never going to have a perfect fit because you're right. Our village code is inadequate. If they're not cooking food and providing a table service, then I would say this is carry out. And then we're able to put it in and move on.
Robin?
Hold on, if we're gonna start doing that, give me a minute to look.
Yeah. well,
Yeah, I think we've got problems with calling it carry out because part of the definition is provided the area devoted to customer seating is clearly accessory to the main business. And in fact,
Correct.
there's a lot of area devoted to seating. It's a
Yeah.
big
big
space that's
seating thing,
devoted
yeah.
to seating. So
Well,
normally,
there's a lot of seating, that's true, but the question is it accessory?
but
And
the
I would,
only,
yeah.
but the only definition is provided that the area devoted to customer seating is clearly accessory to the main business. And this is why I don't know that we can,
See, I don't think there's table service. There's no waiter service. There's,
There is
you
no,
know,
there is none.
No.
I'm fine with calling it carry out. I don't know that it matters, but I'm fine with that.
yeah.
Did they apply? They didn't apply for that. Exactly, didn't they? No.
They just said
They-
restaurants.
Yeah, yeah.
The only time that it would matter if it's a carryout also is if it's in the C2 district, it has that 200-foot limitation to another carryout, but this is in the C1 district. So that
Call 'em
doesn't
food
apply.
ser- You call them a food service establishment? That's the combination, isn't it?
Yeah, we could call them food service establishment, which is how.
Yeah, maybe that avoids it.
Well, then you're just putting it under the general
Yeah.
definition.
It's a little hard to say 21 seats is a carryout place. That's
That's the problem. I
it's
have
a little problem. I'm not suggesting it's insurmountable, but it's an issue.
I understand, but then you're handicapping somebody who just happened to put a bagel store into a bigger space.
Yeah, but if we
Um,
call
Find
food
the argument
service esta-
having anyone. I don't see what, since it's in a C1 district and it doesn't matter about the 200 feet, therefore, I don't think it matters what we call it.
That's my thoughts exactly. So why not call it
So
a
that's,
carryout?
so then therefore, let's just call it a food service establishment.
Yeah, then you,
Covers everything, and it's any of them.
You guys know the history of the board more. I don't know if you've ever done that before. If that's the way you want to go, I certainly don't have a problem with it. Doesn't
Well,
matter to me.
it's defined in the code as being for restaurants, carryout restaurants, delicatessens, and fast food.
If
I mean, they-
anything, I would say,
deli.
I would say if anything, this is a delicatessen.
Yeah,
You
yeah.
go to
But
the
I'd rather not-
definition
but- yeah,
of delicatessen, this really fits within that definition.
but I think if we just
Oh, no,
call
it
it,
isn't, because that says no on premises. It doesn't fit within anything.
Right.
So I would go with food service establishment,
food
leave it at that.
Fine with me.
okay. You have that, Charlie?
Got it.
Food service establishment, not bagel shop. Anything else on this?
Yeah, and we have mentioned we have commented on this multiple times that the village code needs to be amended with respect to the definition of restaurant, that the definitions do not work.
Just that
And
one.
a couple of years ago, I don't remember when, the board at the time discussed sending a letter to the trustees listing all, or you never can do all, listing those portions of the code that we think really need to be revised. And I know the village is doing, the comp plan. In the theory, once they update the comp plan, they should revise the code to conform to the comp plan. I'm not sanguine about that happening. So it strikes me that we should, anyway, that's not related to this, and we don't have the time, but that's something we might in the future think about doing. But
I know-
moving
I
on to
know-
this application,
Mm.
I have comments on the, leaving aside the food service establishment, I have other comments on this, on the draft. Oh, we didn't discuss it yet, so we didn't finish discussing it.
Okay, go ahead.
I just had comments on the draft resolution that you prepared, but if we're discussing the substance, I see no reason not to approve this. I think it's a use that was there before. It's
Right.
it's a different use, but
Right.
it's continuing. We've not had problems with the
Okay,
existence of a restaurant at this location, and I think it continue. It's more or
we-
less, it's a very similar type use.
okay. Are we all right?
I have no issues with this.
Your motion?
Well, first I have comments on the resolution, the draft resolution.
Well, let's hear them. Come on, come on.
Right, but
Okay.
wait, is this it's a
Second.
closed? Yeah, okay, go ahead.
Second whereas clause. Well, it's the first whereas clause. There's a lot of, I found that something part of this to be very confusing, which is in the first whereas clause, it says, 690 has applied to this board for renewal of its special permit to operate a restaurant within an existing building located at 690 Mamaroneck. The premises. What was unclear to me and is confusing throughout is whether the premises refers to the restaurant or the building. And I think different, and if it's only relating to the restaurant, then the definition needs to go after the word restaurant rather than after within an existing building located, because as it is now, the
Okay.
defined term seems to apply to the building. Since
I think as it's written, it applies to the premises.
Well, it's a mixed-use
Right.
building. It's apartments upstairs.
Right, but we're only talking about the special permit for the restaurant. And there's a lot of
Right.
further in here where it matters whether or not we're talking about, for example, the premises would require.
Show up
The
elsewhere.
building requires a lot more than 13 parking spaces. It's only the restaurant that only requires 13 parking spaces. So we need to be clear. We need to either have the premises apply only to the restaurant, or if it applies to the building, we need to have a defined term, the restaurant space.
Well, the portion of the building that is occupied by the restaurant.
But Brian, because of the
building
way
and-
the.
No, I heard what you're saying. It's a
You're right.
very good
Right, it's a
point.
good point.
It should be relegated only to all of this resolution and the parking and everything else.
Correct,
should
but we need
only
to
be re-
define it in the first
Right.
paragraph, so the
Where else
definition.
does it show up we use the word premises?
Every paragraph, so the second
it's-
whereas,
it's
whereas the
throughout.
premise is part of a larger mixed.
All right, then if you want that, then when I say to operate a restaurant,
Well, I think it's much simpler.
no,
if
it's
we
much simpler.
just
You're right. You're right.
Move the premises, since we don't talk about the building at all, except the restaurant, the building is part of a larger building. Why don't we take the definition, the premises, put it after the word restaurant,
Right, right. And we can get,
and then we're safe, then we're done.
yeah,
Yeah.
that's fine. I agree.
Yeah.
Also, just so you know, I fixed, this is not a renewal of a special permit. This is a request for a new special permit. That was from the
Okay.
prior application.
Okay. Anything else, Robin?
Yes, now okay, so we've corrected that. Now it makes sense at least.
Yeah.
So, no, okay, on the, in the, wait, 1, 2, 3, 4, fifth whereas clause, it says the proposed restaurant is compliant with the parking regulations and consistent with the prior. When you say prior, it sounds like this, there was a prior special permit. It's not a prior off-street.
So
parking
with the
variance.
existing
It's
parking,
An
variance-
off-street parking variance that was granted in 2018.
so how about say with the prior, instead with the existing parking variance?
That's fine.
Okay.
Well, is it
Okay.
existing or did it expire?
No, it
No,
does,
variances don't expire. Variances run with the land.
yes, consistent with the existing parking
Okay.
variance. All right,
Okay, in the next to last whereas clause on that page,
the board consider, yeah, that's right.
it's the board considered the applicant's special permit application, the materials, public comment. Again, I don't recall there being anyone who spoke, but I could be wrong. And if there was no public comment, we shouldn't say it. We should say there were no members of the public spoke.
We should really this should be a form that tells us, and the public was afforded an opportunity to speak, but whatever.
Correct. Well, we don't have to say that it was open to the public. It was a public hearing.
Okay.
I think that's what we need to say. Okay, then we get to, okay. So then, and now we get to the be it resolved. Now there, the premises is more likely seems to refer to the whole property. The premises is currently improved with an existing building. So I think this should be rewritten to say the premises is within an existing building.
Okay.
And was previously, and we could say, and was previously occupied by a restaurant. Then we go to the premises located on the next whereas clause.
Yeah.
It says the premises is located on Mamaroneck Avenue with apartments in the building, in the area, but it's also in the building. It's a mixed-use building. So we should say the premises is located in a mixed-use building, right? We need to
Yeah,
say that.
because it came on Amerenik with apartments in the area that, I don't, yeah.
Right, it's in a mixed-use building. There are other apartments
Yes.
in the area, but it's in a mixed-use building, which is a more, no, then it says, and as such noise and amplified or live music must be mitigated. I'm not worrying about mitigation. Mitigating implies that you've created a problem. I think, and that consideration must be given in whether or not, that they have to be kept within appropriate levels. You don't mitigate something unless it's a problem, and it hasn't been a problem here. So I'm not sure that it's appropriate to say such noise, and that we don't have any noise or amplified or live music conditions, which don't exist here. So not gonna have live music, so I don't think some of this should be here. I think instead we should say, the premise is within a mixed-use building, and noise, including music, must be within appropriate levels, and must be within appropriate levels, given the residential use.
Okay,
Something like that.
Well, the second half of that paragraph is with the hours of
fine.
operation noted below, the fact that there's no
Yeah, the second half,
amplified
you're right.
music.
The
The
second half is
use will
fine. The
not
first half-
adversely affect the public health. I think you just get rid of the part of the paragraph
okay,
dealing with mitigation and just go with, the limits.
I think we
Which one?
might just say the premises is located in a mixed-use building. I think we should say that.
Okay.
Yes.
And, but you're right, Brian, that would do. Okay. And I don't have any other comments.
okay, is there a motion on this?
Wait, Brian, did you have any?
I'm sorry, Brian.
No, I didn't. I think Robin really actually hit very important points. I think it's good. It's pretty cut and dry. So I would move. I would move to accept the resolution as as modified based on what we've discussed.
Okay, I'll second that.
Seconded.
All right, we both can, fine. Okay, Brian,
Yes.
Robin?
Yes.
Yes, and I vote yes. Okay, it's adopted. Charlie, you'll get that to me?
Yep.
Okay, let's go on with the next one. The remorse. Okay. The next matter is, sorry. Application of Nicholas Katapotis for North Shore Farms Holding Corp. Special permit tens SP 2018. This concerns an application for the extension renewal of a special permit for North Shore Farms. I note that there was a delay in filing this, but it was because of the pandemic and subsequent flooding. I see no pictures of the water, but I'll take that. The last application was approved in May 25 of 2018. The applicant here.
We are, Chair. Good evening again, Andrew Spatz for the applicant.
Also known as North Shore. How are you, sir?
I'm doing great.
All right. So, you have anything to say on this one? You want to briefly?
Absolutely. I think the application speaks for itself. On the first time in my life, I really have nothing to share to say.
I have one question, which is for the board. We need to also grant an extension of time to file the application.
Yeah.
for the renewal.
Right, that was going to be my question. What are the rules pertaining to renewals and under extenuating circumstances and such? So I think Robin, you just answered it.
Yeah, I think we should, one of the things in any resolution would say that the application was to be made, was it?
In the past, Dave, what we've done,
Yeah,
I don't remember, is we've actually done it as a separate, in other words, first we grant the extension as a separate action, and then we approve the renewal of the special permit, so.
And just to be.
And what's this about the flood proofing on that, condition G on the last one? It shall be compliance with the requirements for flood proofing of building structures.
Chair, could I?
It's funny to see that and then to see we had to extend the time.
Chair, could I expand a little bit on that, or?
No, just a minute, hang on. So we're gonna make, first is to give them an extension of time. How you were starting to say, Robin, and just you want to make that motion?
Oh, I wasn't gonna do it today. Do you want to do it now? The motion for extension of time to file, we can do now.
Oh, no. Oh, I see. You want to do it at the end? All right, well,
Yeah,
fine.
I don't care. I don't care,
Go
David,
ahead.
whatever you want to do.
Go ahead. No, that's fine. Doesn't matter. Go ahead. Well, in a way, it logically does, because you're not hearing it otherwise.
fine. I move that we grant them an extension of time to file this application.
And I will second that.
Fine, Brian,
Yes.
myself, all three. Yes, go ahead, Mr. Spatch, for the pending application. You have anything to add to it?
Yeah,
Is there
thank
any-
you. Just briefly with regards to G of the application back in 2018. As you could see, it made reference to the original site plans that were approved from May 24, 2017. And what was included in the site plans, Chair, members of the zoning board, were certain protocol for preparedness for in the event of a flooding situation, which included certain apparatuses that would be installed. But as you know, Ida occurred in the middle of the night. So I'm not aware of what actually took place, but I know that they had a protocol in place in the event something like that were to occur. As everyone knows, it was a devastating situation, not just for that particular area of the village, but in other parts. Even with the flood apparatuses that were in place, I'm not even sure if that would have prevented the destruction that particular evening. So, but I do know, and I was the attorney that assisted Brixmore, the owner of the property, and the applicant, North Shore Farms, back several years ago. So that was part of the requirement.
Okay.
Right. And so my question to you is, the applicant is not asking for and is not going to make any changes in the business or in our resolution. There's just strictly just asking for continuance, for new dates on this.
Perfectly stated, Mr. Gladstein. Yes.
All right. We know that the plaza that they were in was completely overwhelmed. That was the same plaza with Duck Donuts. I know that when they built that plaza, when they redid that whole site, as much as could be done to mitigate flooding was done, and there was nothing that could have anticipated for this storm. So
Thank you for your understanding, and we're very thankful, I think, as a community that North Shore Farms reinvested the resources to return back to that particular parcel, that property. So we're lucky, and we thank you for hearing our application this evening, and I apologize for its tardiness in seeking the renewal.
Okay. Anyone here have any comments? Does anyone in the public has any comments? Is there a motion to close on this?
I make a motion to close.
Second on this?
I'll second it.
Okay, Brian?
Yes.
Yes, I vote yes. Robin?
Yes.
I have a question.
Yes,
You
Chair.
want, no, not for you.
Sorry.
It's a closed hearing. I won't even listen to you. Brian and Robin, do you want to just vote on this now?
I'm okay. I'm ready to vote on it. I don't have
Are
any.
you, Robin, or not?
I don't know what we have to, I don't know that we have to amend the resolution because we're not going to just issue the same resolution. So what are we going to vote on? What's the resolution going to say? Not going to matter to them. They're still operating.
Okay. Closed. Okay.
Chair, before we move, this is separate and apart from this application, just if I could for 5 seconds. I've sat here for the last hour and a half resonating on some of the things that we discussed earlier. And I just, again, as someone who sits on many boards in this community and directly, Mr. Gladstein, I take to heart what you shared before earlier this evening. And I'm hoping that the presentation I made before did not in any way affront either you, Ms. Kramer, or Chair Newfield. I understand implicitly what it's like to sit on various boards and committees in this community, and I respect that. So I hope that nothing that was communicated was deemed as such, and I made sure that my presentation reflected that and try to quelch any misnomers of what the process is. So I don't want, I don't want to drag anything out, but I want you to understand that as someone, I truly do understand what it's like to be in your shoes. And I hope that nothing that was shared or communicated was an affront, at least from my point of view as an advocate for the applicant.
Mr. Spatz, what I was trying to address was in no way reflective of anything that you said or your behavior. It was just an effort to educate any members of the public who are out there so that they have an understanding of how the process works, and specifically why this application could not be decided on instantaneously.
Understood.
That's it. We're all.
Good. Just want to make sure, as I said, I thank you, and I know many people out there thank the hours that you put in towards all of you as a committee. So thank you. I appreciate that. All right. Have a good night, everybody.
No, thank you.
Right.
Thanks.
All right, the next matter is just. Wait a minute, I got one. This is 551. Oh, there we go. I'm sorry. The next is the application.
You were right, 551.
Yeah, 551 Halsted. I'm looking for the name of the application. Is it Anthony?
Alessius.
The restaurant's name will be Alessia's. It's Chef Antonio.
No, I'm just looking for I'm just looking for the applicant's name is all. Okay, so it's 551 Halsted Avenue. It's application 17, special permit 22. Okay. And we have the application here for the special permit. Okay. The applicant here?
Yes, good evening, Chairman and members of the board. My name is Alyssa Manfredonia. I'm here from Thomas Haynes Architects Office, representing our clients, Mr. Lancione. They will be proposing to open Alessia's Restaurant, which will be a Italian restaurant. And we are proposing a change of tenant, not change of use. Currently, the existing space is a restaurant, and it's been that way for many years. And we will just be proposing to, change tenant. We'll be doing some interior alterations consisting of providing 2 new handicap bathrooms, renovating the bar area to provide a new larger bar as well as handicap accessibility. And we will just be, taking out some banquet seating and redoing the seating. There'll be no change to any exterior conditions, any parking, any bulk requirements or any zoning. It will strictly be just a change of tenant. If you guys would like, I could share my screen to walk you through the plan, or I can answer any questions that you may have.
There's no change in the number of seats, correct?
Correct.
Thank you.
I just have a technical question. I've never seen this before, maybe because I don't remember it or because it didn't happen. But you have on your answer that this is an application for a special permit is required by village for a change of tenant. It's not, it's for a new restaurant operator, right?
Correct.
We've never
Yes.
used that phrase, Robin, to my knowledge, ever, have you?
No.
No, it's strange.
Okay.
It sounds like it's a unique thing. It's not. It's really, there's a change of tenant because the existing restaurant is gone. You're a new restaurant. So it's because you're a restaurant that's new as opposed to because you're a tenant. I just want to clarify that, but fine.
Okay.
So that should just be for a restaurant in a space.
Correct.
Yeah.
Correct.
And then we can talk about the definitions of that. Okay.
Well, I tell you, I understand what you're saying, Dave. For me, when I saw that, it kind of bespoke to the fact that they're not making any changes to the
Right.
number of seats or parking or structure, externally. So I think that maybe that was the mindset on that, but it is a new restaurant, and that's what the permit's for.
Right. Right. No, I agree with you that way. That's very helpful, but maybe we should have a checkoff box for that, but it's,
We don't, it's a new restaurant, that's it.
that's it. Okay. Yeah, you want to just go through it quickly with us and you have, I mean, are
Did you want me
the same
to share the
seating
screen and walk you through the plan?
Yeah, I'm just looking at one thing. Your survey here is 23 years old. That's the problem, I see. I don't know how no one pointed that out to you, but it's a 1999 survey.
Did you submit a new survey?
So due to the fact that we weren't doing any alterations to the exterior, we believe, and from speaking with the owner, and they've said that, you know, what this conditions are what they are now. So we didn't think that it was necessary to, you know, get that updated currently, as we're not doing anything on the exterior.
Well, I understand what you're saying. I mean, I think at a minimum, if we're going to accept this, we need an affidavit of something saying this is
Mhm.
current.
Yeah.
But we
Okay.
can't, here's the problem, Dave.
Yeah, I know.
No,
Go ahead.
no. The owner
Yeah.
wasn't there 23 years ago, so the
No, I-
owner doesn't know if the prior owner does. I don't think we need a new survey. What I think we need is for a surveyor to come out and do a
And
survey
certify it.
update and to
Yeah.
certify that this is what it is. It still is this, whatever this is. So I think that's what we need. I don't think a new survey, a complete new survey is
I agree.
necessary. But we can't get a survey
It
update.
needs either a new survey or a certification that this is correct by a surveyor, by a licensed
surveyor.
surveyor, engineer, whatever.
Yeah.
It can be an architect, an engineer, right? Architect can do that, right? Licensed architect, engineer, or,
But an architect isn't surveying. Again, you get to the same.
I prefer a surveyor.
okay?
Let them just update the survey.
So you would prefer an updated certified survey, not an affidavit or a letter from a design professional?
correct,
Correct?
We
Yeah.
don't, again, we don't
Ryan, I
need
don't
an
know if you need
updated.
an updated
just-
survey. Robin was talking about not an updated survey, but about trying to think of
An
the
update to, in other words, the
Yes.
surveyor comes out and
certification
looks
that the survey.
whether or not it's the same. And I mean, you see this on surveys all the time. The
A
surveyor goes
surveyor's
out and says,
certification.
updated,
Correct,
no
correct.
changes, and that's all he says. And that's all the
Okay.
surveyor says. It says no changes.
Okay, done.
Right, we don't need a new survey. We just need some certification.
Perfect, got it.
We have a menu here if somebody wants to order. But the same layout inside and everything, right?
No,
No?
So the interior alterations that we'll be doing, the layout is very similar in the sense that the kitchen is in the same location, the bar is in the same location. The existing bathrooms are going to remain. The only work that we will be proposing is providing 2 additional bathrooms that are handicap accessible, considering the existing bathrooms are not. So we'll provide that, and we will be demolishing the existing bar and providing a new bar that also has handicap accessibility.
oh, you're also, you're going to be doing a complete aesthetic upgrade from.
Oh,
the walls
aesthetics,
to the
yes,
ceiling.
correct.
You're going to be changing the table settings. It looks like currently, do you have some booths which are going to be?
Yes, like I mentioned earlier, we'll be removing the banquette seating and having some freestanding tables and seats.
Right. Now, what about in terms of the kitchen? Are you changing any of the equipment? Are you replacing? Are you upgrading?
There will be some direct replacement of equipment. The layout will be the same, but there will be some equipment being upgraded, correct?
Okay, and are you, what about the ventilation, the hoods and things like that? Are they being upgraded or they're being replaced in
So-
kind or nothing or?
They will be, some of them will be replaced in kind. We do have a professional mechanical engineer involved in the project who will be doing all of this. In regards to any type of equipment for ventilation, HVAC, it would all be, if need be, replaced as in kind in same location and no change to any, you know, not adding anything to exterior or anything like that.
Okay.
Okay. Anybody want to go through the plans, or is that not necessary? Robin?
Just give us a very quick overview of it. I think is fine. Not more than 5 minutes. That's how little. Just. I mean,
Yeah,
I
if
looked
you
at some
could,
of it.
if you could bring up page A102. Right.
Can you
That's-
see my screen now?
Yeah.
Yeah.
Okay, great. So let's see, we're gonna go to A102. Okay. So this is the current plan. As you can see, we have our main dining, bar area, entry, and some more existing dining, private dining area.
And the
For our new-
area where the new bathrooms are gonna be is currently what?
A reception area and a closet.
A closet.
Yes, so right over here is the current area where the new bathrooms are gonna be. Also, it is where one banquet seating is. So that'll all be removed. Everything dashed is going to be removed. As for the new plans, walking in on the same existing entrance that's right on the corner, we will be removing this small kind of foyer entrance to open up the space where you'll walk directly into the bar, which is going to be have the handicap accessible counters. And then on the left-hand side, you can see here, we'll have these two proposed handicap toilets in the area where the previous reception and walk-in closet was. As for the main dining, table layout is a little different, as you can see, but the general space is the same. We're going to add some wine storage, private dining, same thing. Seating is a little bit different. We added some banquettes here compared to some freestanding tables that were here, but the existing waiter station will remain, as well as the existing toilets over here, and the same as the kitchen in the back. There will be, when we have to file for the formal building permit, like I said, there will be mechanical drawings and more in-depth information about what equipment would be replaced in kind, but for the most part, things will remain as they are.
The only question that I had, and it's not necessarily to the applicant, I had asked Brittany earlier, was I thought it would be helpful if we had a copy of the previous restaurant's special permit. I don't believe, Brittany, did you say that that's not available to us?
The only reference that it was made in our system is 1982, and I cannot find it.
So that would have been, I guess, just done in perpetuity.
It doesn't seem like they renewed, that I'm aware of. I asked around the office. It didn't ring a bell to anyone that they had renewed.
Okay, because that, it would have been helpful just in terms of it speaks to parking and some of those other things that we always deal with.
Yeah, we're still, trying to see if we come across it at any point.
Yeah, that's reaching back there. I remember 1982, it was a good year. But I don't know if we have, it's 40 years ago.
The village
It's scary when you
requirements
say that.
changed anyway.
I'm sorry, what did you say?
I said the code requirements may have changed since then.
Well, that's true, but it was continuously used as a restaurant, so I didn't know whether or not there's any pre-existing non-conforming. It just would have been interesting to see what it is and make our determinations. Is this, I didn't see, is this a C1? What district is this in?
This is C1, a C1 district.
So Charlie, what parking codes?
I just wanted to make sure that the applicant walked us through the parking configurations, because it does look like the seating has obviously changed. So to the extent there's more or less seating, just making sure we're compliant with the off-street parking requirements.
Yeah, so our seating number is the same, although the layout is a bit different. The seating is the same. And, the parking is the same as it is existing too. So it will be the same numbers.
So when you redid the seating, you expanded the number of seats at the bar, but I see that you got rid of some of the tables. I think they were 5-seaters and now you're down to 4-seater. So the 136 patrons stays the same. You're not counting the bar as separate seating.
We include in our occupancy calculations, how that is added into it as well.
Thank you.
So that is included in it as well.
Fine. So, yeah, so the patrons hasn't changed and the parking hasn't changed, and that's why I was asking for the old permit.
Right.
Yeah, that's because I don't know whether or not based on the current regulations, there is enough parking. So as to Charlie's thoughts, if you could walk us through the parking and tell us how many spaces and where they are and all of that, which is, available to the patrons of the restaurant, that would be helpful.
So currently, all the parking spaces are actually, the lot's a pretty unique shape, and all of this parking back here, if you can see, is for the restaurant only and for the property. So we have, I believe it was 36. We have 36 parking spaces for.
You have them delineated on any of
property.
them? Are they
Yes.
delineated?
I'm sorry, can you say that again?
Are they delineated? Are they set forth and diagrammed in?
Yes, everything's right here. If my screen is still sharing.
Yeah,
So
it's shown
the
here,
7
David.
Oh, I'm
spaces
sorry. Yes,
here,
yes. I don't.
16 spaces here, and then
Yes.
3 spaces here
Rob.
as well, and handicap space
Right.
here.
Okay.
Now, I hate to be a stickler, but I've passed the restaurant many times. Where does your garbage bin interfere with any of those parking spaces? Where do you keep your where do you keep your garbage? It's like a big, one of those big metal things. Where do you store your trash for the facility?
So from my understanding, and I believe the owners are on here as well. So if there's anything you'd like to add, please raise your hand. I believe that the existing garbage is in this space over here, not interfering with any of the spots.
Okay. So I mean, you do have a space for it.
Yes,
Okay.
correct.
Do we have in the application, was there, and I don't remember, one of these parcel history things that we often get?
Yes,
Because
I can pull that up if you'd like.
Oh, here it is. I see it. Because I'm just trying to figure out, going to the parcel history to answer the question of how long the restaurant was there. So it was there. So 19.
Special permit was listed on the parcel history as 1982, I believe.
Right,
Yeah.
but we had a restaurant. I'm looking to see when the restaurant first showed up, and I don't see. That's what I was trying to figure out. There was a parking in 1970. There was a rear addition and parking area for restaurant. So the parking has been there since 1970, at least.
And in actually 57, there was a facade renovation to the
Right, but we don't
restaurant.
know what it was a facade renovation for. It could have been a store. It didn't have.
Oh, no, it says for restaurant,
Oh, it
restaurant.
does? Okay, so the restaurant, oh yeah, I see. Well, no, I don't
Sorry.
see the other one, but, so it's been there for a long time. My point is the parking seems to have been added in 1970. Because
Yes,
that's with
from
the permit, rear addition and parking area for restaurants. So whatever they did in 1970 is when it looks like,
they had to extend the parking area for whatever they added. They must have had to extend more and add more parking.
well, had to or chose to satisfy their customers. I don't know, whether or not that was a requirement or whether or not they were just trying to
Right, we don't know what.
be more attractive.
The other thing is there's a page in there that I see. It says page 3. I don't know what it's attached to. Or maybe it was this applicant to the 1988 application for special permit. That must have been, never mind. I see what it was. So that was a special permit to enlarge the kitchen. Right, but we don't know whether there was something before that.
I believe it was still Chef Antonio's, just due to the description saying to expand existing kitchen at Chef Antonio's restaurant. And that was in 88.
The resolution is there. Or maybe it's not.
I
No,
think
that's,
this
that was a
is the
resolution just to do the kitchen.
Yeah, with a special permit for kitchen.
Mhm.
As I said, 1970 is when they certainly either expanded or added the entire parking space.
Yeah.
Mhm.
Okay. And the restaurant was in existence prior to that. So
Back, the restaurant was there, I think we just read, since the 50s.
1940.
Correct.
40s. 40,
Sorry, I just had it. I mean,
19, well, I
33,
I
it
said
says
1957.
sorry, I had it a minute ago.
Yes, 57, it says facade renovation for restaurant.
So at some point at 57 or maybe a little earlier, I don't know, there was fire repair damage. Robert Rakert, he was running a store.
Yeah, so in 1940, there was a store because it says
Mhm.
two-year
Right.
alteration to store. So sometime between 1940 and 1957, the restaurant was open.
Correct. So it goes back to the 50s, that we can be sure of.
Mhm.
So I don't know whether or not the parking rules apply to, because if we go back to the 576 Mamaroneck Avenue hearing, if it was operating as a restaurant prior to April 1st, 1968, and it was, then they may be exempt from,
All parking requirements.
yes, which would be helpful with our deliberations.
But we know there was a restaurant there because it says in 57, there was a renovation for the facade, which means there had to have been a restaurant there because whether it was just being installed in 57 or it had been opened before 1957. But yes, I think it looks clear that, and there was nothing that shows that the building itself was, and in fact, they had a permit. So it was a building permit. What it says is it talks about a building permit issued before 1968. And this clearly shows that there was a building permit for a facade renovation, which means there was a restaurant there, which means I think it is grandfathered under that section. Or that section is applicable.
Yeah, I would say that. I would also say to the applicant, do you know when Antonio Mastrangelo purchased the property? Because it looks like it was already a restaurant. You know, you would think if he's asking for a permit in 1970 for a rear addition and parking area for the restaurant, you would think that he was already in possession and running a restaurant. So he may have actually opened that business prior to. Is there anything that tells us when he opened Chef Antonio's?
So the only thing that I can pull up, and once again, the new owners are present. If you guys have the answer to help with this question, definitely raise your hand so you can advise. I do see that it was from these documents, I believe it was 88. He enlarged the kitchen, so he must have owned it previous to 88.
Well, yeah, but his name is on the, is on.
Oh, he was
the-
on there for 80. Sorry.
No, he was on there for 1970.
Oh.
And our parking regulation started in 1968. So regardless, actually, it's a moot point. Robin has already said that it's been operating as a restaurant since the 50s and it should be exempt from the
Was there
parking
something that
regulation.
says facade renovation for restaurant 1957?
Yep.
Implies there was a restaurant in 1957, although I don't know the details of it.
So I guess our typical questions, perhaps, does the applicant intend to have live music or amplified music or outdoor seating or open doors at any point in time?
They do not, but I can see here that the owner is actually raising their hand on the presentation. So they might want to say something on behalf of the application, if that's okay.
Yes. So, yeah. So they've been promoted, so they could just speak now.
Oh, hello, can you hear me?
Yes.
We can.
Oh, hello, everyone. I can't see you. Oh, there you go. Hi, everyone. I just want to mention, I want to circle back to the survey, the first note that I made here. We do have a new survey ordered. It should be, yeah, there we go. It should be, I think on the 29th, they were certifying it. So we should have it soon for you guys.
Good.
Yeah, yeah. And I'm not sure when Mastrangelo, I'm not sure when he purchased it. It was before my time.
I've been in talks with
Literally.
Literally, exactly.
I've been in talks with the owner of Chef Antonio's now, and he had the restaurant for 40 years, and before him was when they named the restaurant Chef Antonio's. So it's been a restaurant well over 50 years, that's to my understanding. It's a beautiful spot, and I'm looking to do great things.
So do you intend to have any live music or amplified music?
That's not what we do. Only background music, typical restaurant background music. Nothing loud. It's not it's a family
Yeah, so
restaurant.
we're a family restaurant.
Yeah.
Have you submitted your requested hours of operation?
I believe it's submitted.
Yeah, I believe Alyssa has it.
Yeah, it's
They are
right-
on top
It's on the
of
menu.
the menu.
Yeah,
Oh, they're on
backside
the
of the menu.
menu.
Backside of the menu.
Okay. I thought that was just creative, like trying to get trying to make us hungry or something.
Well, typically the hours operation from Monday to Sunday,
Yeah, got it.
from 11:30 or 12 noon to 9 o'clock at night. On Friday and Saturdays, typically to 9:45, and Sundays is most likely closing at 8:15. Kitchen closes.
Okay.
We have any other questions or? Yeah, it's 10:30. We have another big one. And
I have no other questions, but Brian?
No,
does anyone
I
here?
think we
Public have any?
covered it.
I think we can close it.
Okay.
Well, I guess did you take from the public? Sorry.
I just asked, is there anyone else from the public?
Nobody's raised their hand.
Okay. Very good. Is there a motion?
I'll move.
Oh, or Brian could move.
All right, we got a motion to close and there's a second. Okay. Brian?
Yes.
Bob? Okay, the hearing is closed and no decision will be made. What you should need to do is, and I just want to qualify that, It's closed subject, however, to the receipt of the certified survey. If the survey is not the same, we'll then address it and it'll be a continued hearing. But otherwise it won't be. That's the only issue. So if you get that to us as soon as you can, and we can move on it.
Wait a minute, I know we just closed it, but I think we can unclose it maybe. The question is, and this is a technical question,
Oh,
if it turns out that there's been changes to the survey, I'm not saying there are, but if
Right.
it does, and we'd want to discuss that or consider it, and we've closed the hearing, do they need to, they might need to renotice, so maybe we should
Well,
not
I
close
just
it.
said, I just said if we closed it, I said we're closing it subject to
Mhm.
the receipt of the
No,
survey.
you said subject to receipt of the survey, but my point is
No, and if
that,
there's any questions, then we would continue the hearing.
then maybe we can't close it. I
Right,
don't see how we
so
can close
Robin
it.
saying,
Yeah, I know, I
Just
understand. Yeah, Charlie, isn't there a special provision that if you want to reopen a hearing, it's not like a whole new thing to reopen the unanimous vote?
You could reopen it. The only thing that would have to happen is you would have to renotice it. You know, the other issue is that even though the public hearing is closed, I know this isn't the practice of this board, but the applicant does have the ability to address the board even during a closed hearing.
But not with our board, because we haven't done that for 25 or 35 years, so.
I think Robin is right.
So Robin's right, so.
Leave
we're
it,
gonna
just leave it open. The only questions we have open are the survey and it's our practice sometimes to be able to prepare a resolution in advance, so it should not hold up the whole process.
Okay, so we're gonna leave it open, but we don't need to have them here, do we, if the survey is accepted?
No,
Okay, so we're gonna keep the hearing open because it's more technically correct, and then what will happen is we will leave it open and we will get the survey. And if the survey matches perfectly, you don't have to be here. If it doesn't, we'll give you a call.
All right, so when I have the survey, I deliver it to the building department?
Yes, yes. And do that. Now, you think that'll be when, by the end of the month, hopefully?
No, it'll be
Oh,
very soon.
next
It's-
week.
It's already, yeah, it's already in
Um,
full process. They were there on the 29th of August. So I should have it any day now.
Great.
I should have had
Make
it.
sure you bring it over to our office, just to clarify, not the building department, back to the planning department where we are.
Okay, yes.
And while I have you here, because we may not see you again, the garbage bins for the restaurant, I'm sure that you're not opposed to have those odd spots in the back designated for them as opposed to having them in the 3 spots on the side street.
Absolutely not. Actually, I had a conversation with Suburban Carting this morning. And as soon as I get the keys to the place, we're gonna situate where the best place for the receptacles would be.
Yeah, well, based on the parking spots that are there, if we make an approval, those parking spots are designated as parking spots, especially for the handicap.
Mhm.
It also, it's not a good site for your restaurant. A lot of people.
I personally
very-
don't like
It's
it.
very visible and to have trash bins like right there, is especially when people have to pass it to get into the restaurant. It's not a.
Absolutely. So, yeah, I'm with you on that one. So as soon as I have that meeting with Suburban Carting, we're gonna put it into a nice spot, maybe even fence it off, if that's possible. So,
You'll see.
All right, so we're going to adjourn for tonight. Thank you so much.
thank you very much.
Thank you.
Hope to see you.
And hopefully the survey will be here. We won't see you again.
Or come to the restaurant, I'll see you.
At the restaurant. Okay, that'd be wonderful. I got the menu, so it's all set.
Right.
Thank you very much.
All right.
Thank you. Actually, one quick question. Once I get the survey, then we have approval?
No.
Assuming that it's the
Okay.
same?
Once you
I'm a
get the
little confused.
survey, then we will close the hearing.
Mhm.
After we close the hearing, we have 60 days to deliberate and vote on it. We will, in all likelihood, if we get the survey, either deliberate on it at the next meeting, which is in October, or the latest in November. Do you have a lease now in place?
Well, right now, we're actually in the process of buying the building also.
Oh, but, okay,
Yeah, so we're
Yeah.
running the restaurant, but also buying the property.
okay, all right. So
It's a sticky situation. We don't have a leaf, but we're
So
buying
there's
the-
a possibility that it may go till November? the
I-
pending
We will
approval?
try- You get the survey to us, we will try. We're telling, I think all of us would agree, we will
Mhm.
try to have this resolved to the next meeting.
Yeah, it's.
I would
it's within-
expect that to be the case. I really
It's
would.
within 30 to 60 days.
Yeah, we have 60 days from the time we close.
Yeah.
But if we get the survey and there's no issue, I think it's the intent of the board to close the hearing, and quite frankly, it's a lot easier to just dispose of it than vote on it. But, I can't guarantee that.
I got you.
Mhm.
Okay, but we will certainly understand. We understand that.
Okay,
Thank you very much.
All right, thank you. Have a nice evening.
thank you, you as well.
Thank you. Next matter is application 18 AV 22, 572 Van Rance Place. Maybe they're not here because they went home.
I doubt it.
Oh, please, come on.
Kristen didn't.
Time's
leave.
up. Time's up.
Well, it's at least we saved the easiest for last.
Well, I think we should do is if they're here, we'll start this. I don't think we're gonna go through the whole thing. There's another item we have to deal with too. But if at least they can lay it out and then we can. Are they here?
I'm promoting
They're
everybody.
here.
Ah, Mr. Moto, how are you? How are you?
Can everyone hear me all right?
How are you? Can hear you fine. Good evening.
I'm doing well. How are you?
Good, thank you. Good.
A familiar face.
Good to see everyone again. So for the record, Kristen Motel, I'm a partner at the law firm Cuddy and Fader on behalf of the applicant. We do have our full team here tonight. Jerry Ryan and Brendan Ahern are from DGC Capital. They're the owner's representatives. They actually own the property right now. John Sullivan from Sullivan Architecture, Michael Stein, Hudson Engineering, and Dan Connors, a new face that you probably haven't seen before, from Eris Energy Solutions. I know that it's very late, so given the late hour and the fact that one member of your board is not able to join us tonight, I'll take some direction from you on how in depth you want our presentation. As you mentioned before, Chair, this is a big project. There's a lot of detail to discuss. And we do have the full team here. We're more than happy to give a full in-depth presentation, but I just want to be mindful of your time and respectful of that.
Well, thank you very much. It's kind of you. I think that, why don't we do, it's 10:38. What I'm going to suggest is, and this is flexible, but I think, see, it's not just the hour, but you lose the attention as well.
Right.
But I also understand that I don't want to waste your team's time. Why don't you do an overview of this with whoever you want? Try to take like 20 minutes and then
Okay.
I could be wrong. I don't think we're going to really get to the end of this. There was, yeah, address that. And there was one thing on this one. Oh, I know what it was. Okay. When you address it, if you would also please take a look at the building department's indication of what approvals are necessary.
Yeah.
Because you have here, and I just want you to clarify, planning special permit for 3 of them. Height, parking spaces, and FAR. But yet, I think you've also asked for that here.
Yeah, I think the building department determination has been updated since we submitted this application
Right.
form. And I've worked with Frank to get a new copy of that. So we can provide that as a supplemental before the October meeting to this.
Yeah,
board.
it was sent out to the board separately on, I think, August 30th. We revised it and it was sent out on the 30th and we also posted it to Novus, but it wasn't in the original packet.
When you
Right,
say
and-
sent out, what do you mean? Because I didn't get anything. So-
Email, but you can't access your email, so.
Right, so.
Right, so it looks to me like
Here doesn't even
the
know what this application.
update included a variance for the required minimum square footage for open space, which wasn't on the original.
Yeah, it also dropped the parking variance and there is not a special permit required for this use.
I wondered about those things. I saw them.
Yeah.
But we can, I mean, we can dive into that.
Okay, so why don't you run us through this and you have a neg deck, I believe.
Yes, we do.
On your, okay, fine.
All right, so the premises is 572 Van Rance. That's the RM3 zoning district. So principal permitted use is multifamily residential, which is what's being proposed here. Before we talk too much about the project, I just want to highlight right now it's a 6,500 square foot lot. So it's pre-existing non-conforming. 7,500 here is the minimum lot area. So we're 1,000 square feet less. We also have obviously less width. We're 65 feet wide, 100 feet wide is the requirement. On the property today, there are 2 3-family units, about 10 people can be accommodated there. There's no stormwater management infrastructure, and the surrounding area is, as you know, primarily commercial, multifamily residential buildings. The 5-story Parkview Station condo building is next door, and Columbus Park is across the street. The building is in the AE flood zone. It has a base flood elevation of 25.8. I know that flood zone requirements are not something that this board dives too deep into, but it's worth mentioning here, and we'll get to that in a minute. The existing structure does not comply with any FEMA requirements or any village floodplain development requirements for residential structures. So the applicants, like I said, they own the property, and they're proposing to replace that existing structure and construct a new 5-story multifamily building. It's going to have 10 units, that's it. And it's going to be flood resilient and sustainable. So when I say that, I mean it's going to be powered by a state-of-the-art fuel cell system that can operate independently off the grid and self-power during times of power outages. The rooftop fuel cell system is capable of supplying continuous energy to residents during a power outage. There's also going to be rooftop solar, EV charging stations. The estimates are about like 73% less carbon emissions. It's really an admirable building. And the building is also going to be raised above base flood as it has to. However, it's important to note that the village requires the building be raised 2 feet above base flood elevation. The applicants recognize the fact that they're located in the floodplain, and they're keenly aware of the history in the village. They're also forward thinking. They want to set a model for village development moving forward. They're going to lift the building 8 feet above the base flood elevation to safely accommodate their residents. The 10 units are going to be 6 1-bedroom. They're smaller 1-bedroom units. They're not really conducive to 2 people. And then there will be 4 2-bedroom units. All units are going to be market rate. So they're intended for local workforce or local commuters. They are not luxury. Parking, fully compliant parking, is going to be provided in a garage on the ground floor of the building. The project's going to increase the flood volume storage on site. It's going to fully comply and exceed all FEMA and village floodplain requirements. We're going to install new stormwater management infrastructure above and beyond what is required to manage runoff. And we're proposing new trees, landscaping, fencing. I think you have some photos of the existing conditions on site in your packages that we provided. So we're proposing an upgrade. Procedurally, where we're at, we have a site plan application pending before the planning board. The planning board is lead agency for this SECRA unlisted action. They adopted a neg deck on July 27th. That is about 10 months after we first appeared before them. So I can assure you, as that I know you know, the planning board has taken a very hard look at this application. There are 6 area variances that we're requesting for this board, and I'll provide the updated determination as we mentioned. But I think it's significant to look at this project in the context of the whole picture, including the driving factor behind some of those variances we're asking for that I'll get to in a minute. Some of the modifications, and there were many that were made at the planning board, and we also appeared before Harbor Coastal preliminarily. Those drove the need for variances, right? Modifications.
Can I just stop 1 second? The application pending before us is the one that was revised after you've been to
Correct.
planning, correct?
Correct.
Okay.
Yep. So you're looking at the modified project, not the one that we presented 10 months ago.
All right.
Which plays to alternatives and other feasible methods, but we'll talk about that. So I just want to preface it by how the totality of the circumstances here is really going to dictate the context of the review for this application. And when I say totality, I'm really referencing the fact that public health and safety is at the forefront of this application. The applicants want to seek a model for the future. The village is aware of floodplain development and the projections for, climate change and flooding in the future. Compared to the neighboring buildings, compared to the existing residential structures that are on site, this is a safer solution. It's an overall benefit. So as I mentioned, it's fully compliant with flooding. It's above and beyond, resilient. Environmentally and aesthetically, it has benefits to the area, and it balances fully compliant parking and meeting all of those standards, right? So the variances that we need, lesser side yard, combined side yard, total number of stories, but not feet, just stories, usable open space per dwelling unit, FAR, and dwelling unit per lot area. So talking about totality, and I'm going to go through this quickly, and I'll just turn it over to John Sullivan to review the plans. We're talking about totality. Each one of those, let's take each one at face value, right? So the side yards, lesser side yard and combined. The building itself fully complies with all side yard setbacks and front yard and rear yard setbacks. What doesn't comply is there's a covered area, a platform that is actually designed to be a queuing area for an emergency door that John will show you on the plans, that's meant to provide for emergency evacuation during a significant flooding event should people need to leave the building and get into lifeboats or some form of rescue. And we're looking at, however many feet of water. That was a request from Chairman Burt and the members of the Harbor Coastal Commission. It was also supported by the planning board. So that queuing platform extends into the side yard, and that's driving the need for two of the variances that we're requesting. The total number of stories, again, there's a 50-foot height maximum here. We're only proposing 49 feet, but we're proposing 5 stories instead of 4. Really, it's the same.
Can I just interrupt you for 1 second? Because on the plans on A3.1, it shows the building height is 70 feet.
I think that might be, John, do you want to comment on that? I think that might be, is that AML?
Yeah, no, it's that's the top of the in elevation of the bulkhead of the stair and elevator and the upper floors up there. That's not the top of the building.
Which is exempt from the total.
Which is, well, it's the elevation, I assume, not the height.
Right, that's the elevation, not the
Correct, not
feet.
the height, and
Right.
it's the height that's relevant
Right.
to the building, the zoning code. It's not the height.
Correct.
It's the height, not the elevation. Sorry. Right.
Right.
That's the height, not the, okay, so maybe somebody could actually put that on the plans to call that out, because I mean, you've got the 5th floor at 60 feet, you've got the top, and I know you said the top's just for mechanical space, but there's an apartment up there. There are people living on that.
Let's not
It's elevation. It's not.
No, I heard you. Asked and answered.
Right. So we'll get there. And we'll revise those plans. The elevations, the levels are on there because this project was looked at through a flooding compliance lens with the planning board. So that's why all of that is on there. Really,
Thank
what
you.
you have, no problem. What you have is you have the same loaf of bread, no matter how many slices you put into it. The fact that we have that 5th story is driven by the mechanicals for 2 reasons. One, we can't have mechanicals at or below base flood elevation. They've got to be up 25.8 or higher. Second, the fuel cell, the technology that's required, that's a significant area. We need more space for those mechanicals. We need the full stair to access them. and other configurations. So that's driving the need for the additional story. There is absolutely a 2-bedroom apartment up there. That is for two reasons. One, because there was extra space. And 2, it mirrors the Parkview condo building next door, which is 5 stories. So architecturally, these buildings mirror each other.
I have a
That fifth
question.
story would be required whether or not we had an apartment up there.
Following up on Brian's question, just something, the elevation, the drawing that he was just referring to that shows the elevation doesn't seem to show the solar panels. So where, in terms of height and or elevation, where the solar panels are on top of the roof, but they're not shown, how tall are they? How high are they above the roof?
Or are they flat on the roof?
Well, that hasn't been determined yet, but I would say that there's multiple means in which to construct a solar panel today. Yes, some of those can be flat, but they are probably not technically the more ones that you would want to use. So the typical panels would probably be about 3.5 feet above the roof line.
Okay, now I don't know the zoning code with respect to, and I don't see Frank here anymore. I don't know the village code with respect to the details of it, with respect to height measure. I'm not saying it's a problem, it's just a question. Because you haven't designed the solar panels yet. Therefore, we don't know the ultimate height, including the mechanicals, right? Because you've got solar panels and your fuel cell. We don't know the ultimate height. Does the village code, and you might not be able to answer it today, but get the answer for us, and we'll have to check with Frank. Does the village code include in height, New York City, for example, does, the height would include anything on the roof. So it would include the parapet, it would include the fuel cell, it would include, if it's up there, it would include the solar panels. If it is true that those things should be included, that means you would either have to come back to get a new variance, or you would need to do it now. But I put that out there because I don't know the answer to it. I don't think you've looked into that yet, but something to.
Let me answer your question, okay? That there must be some confusion here. The only part that exceeds above the roof line that we show would be the solar panels.
Fine. Okay.
The solar panels, right? Not the fuel cells. The fuel cells are internal. There's no mechanical equipment on top of the roof. It's all inside the rooms that are there. And we can get into a deeper discussion about how the fuel cells work in a building like this. But again, we also don't show a parapet wall on this building. Parapet walls, when you measure the height of a building, it's to the top of the roof. So if you have parapet walls that are up 4 feet, or a fence that goes around your roof, the height of the building is not measured to the top of a fence or a top of a parapet wall. It's measured to the top of the roof. You ask a very good question about the solar panels. Now, I'm not frankly certain if the village has within their ordinance and where they've established that on, for example, other buildings that have solar panels or photovoltaic panels that are on roofs, where they're measured to. Interesting question, and you're right, Frank's not here, but we'll find out the answer to that. But as this building is measured, the height of the building is measured to the top of the roof.
Okay, then that's fine. So we just need to find out about the solar panels then.
Right. Actually, it's a very good question.
That's a great point. Thank you. So where were we? The next variance is for FAR, and that's more, it's pretty minimal. There's a 1.2 permitted. We're proposing 1.3. Again, that is primarily driven by the substandard lot. And we are, again, only proposing 10 units here. We're proposing fully compliant parking, and compared to the immediate surrounding area, Parkview Station, I think, is 27 units. You have other multifamily buildings in the RM3, over 100 units. The FAR here is really appropriate for this lot. Same with usable open space. When you look at it,
Well, I think, hold on, I think you misspoke. It looks like the proposed FAR is 1.5, not 1.3.
Oh,
Is
did
that
I
correct?
misspeak? John, you want to just check that? Let's see. I think it's oh, you're right, 1.5.3 is the variance requested.
Okay.
Thank you, thank you. The usable open space variance that we're requesting, when you look at the site, specifically, we are directly across the street from Columbus Park. Practically speaking, we're also within walking distance to the train station. While it doesn't count towards open space per the zoning code, we are providing terraces and rooftop areas as open space for the residents of the 10 units. So when you think about the substantiality and the significance of this being directly across from the park, again, that helps balance in the applicant's favor. The last variance we're requesting is the dwelling units per lot area. So like I mentioned, we have an undersized lot. However, 10 units, which is what we're proposing here, would be allowed without a variance if 2 of those were affordable per the planning board. Now, given the cost of the fuel cell here, which is significant, to make the project work, 10 units is required, and they have to be market rate. Now, I say market rate, they're not going to be luxury, but they're not going to be affordable. So we're requesting that additional 2 variances. By allowing the planning board to have an additional 2 for affordable, 10 units is not necessarily inconsistent with the character of the neighborhood. It could be permitted without a variance if 2 were affordable. So, you know, really the building is designed to mirror the conditions in the surrounding neighborhood. It's going to add numerous benefits, which we can get into the details of. I know it's getting late. We have a lot more we could talk about. And the variances, the factors really weigh in favor of not just the applicant, but the surrounding community and the neighborhood in this case. So John, I think if you just want to pull up the plan so we can all look at the same thing, maybe take some questions.
Let me just ask you one question, because I did see throughout the application that you were talking about the need for 10 in terms of economic viability. Do you have any, you know, do you have anything written out to show what the economics of the building are, to show that the building would not be economically viable without the proposed number of units?
So the property owner, Brendan, is on right now, as well as Dan Connors, who is a representative for the fuel cell system. I don't know, Dan or Brendan, if you want to address that now, or we want to provide that in some written materials.
Yeah, I would just prefer if you could scratch something out, you know, because if that's going to help us with the basis for a decision, we really need something to substantiate that besides, you know.
Sure. And I mean, I can vouch for having been involved in this project, and John too, you know, if there was a way to do it without that variance, you know, we would be doing that.
It's a fair question, Mr. Gutstein. We'll get the clients to, you know, help with some financial projection for you to at least show that.
Yeah, I would think it would probably be pretty easy, but we still, I think we need it if we're going to deliberate and make decisions based on it.
Man, based upon that one, yeah,
I don't think
that's fine.
there's anything in the area variance requirements of the village, I mean, or the state, neither under state law or under the local code is financial difficulty of the project part of the finding. So I think we have to be careful there, Brian.
It's understood, but I'll just share with all of you here that we did not go into this and creating a design solution on this obviously very small postage stamp, if you would, parcel here. You know, my clients didn't say, John, you have to get me 10 units. There never was really a specific number in terms of that. We looked at it holistically, like what would seem like it made good sense for this piece of property, particularly knowing what we had immediately next door. We didn't want to exceed a building, you know, aside from the obvious that the ordinance doesn't permit something higher than that. So we were really careful about trying to mass a building that fit within the parameters of the site, as Kristen said earlier, the setbacks. And we can touch on this one in a second regarding this platform, which kicks in the side yard setback. But we masked it out, and you can see that on the renderings on drawing A4.1 that we created that sort of helped maintain the streetscape corridor that's there and at the building next to it. We evolved into 10 units. We had to balance the parking to work for that too. We probably could add another unit on that top floor to the rear, but that's only compounding the unit density. It's compounding parking requirements that just frankly don't fit on the site. The parking is dead level on the site on grade today. There's no subsurface or lower level garage. As a matter of fact, the parking spaces for the most part are not even enclosed. They're covered in part. A good number of them are only partially covered. So what we really paid attention to was that there were no habitable spaces on the ground floor. And as Kristen said, anywhere near the maximum floodplain. We learned a lot from Ida, everyone. And no one wants to create a condition here that floods out residents again. So we were able to put that first floor of elevation 12 feet above grade at elevation 33, which is about 7 feet or so above that maximum flood height. Think about that. This site could get 10 feet of water on it. God forbid if that happened again, and no one would be in harm's way. And by energizing this building with the use of fuel cells, we don't have to rely upon power. These people might have electricity during a serious outage and be able to stay there. But we all realized, okay, they may not get flooded out. So God forbid, what if someone became ill? What if someone, God forbid, had a heart attack? And we had 8 feet of water on the site again, and they had to get out of the building. How would we do that? And that got up to this point of how we created this little rescue platform off the side of the building. You know what, my associate Greg Dallop's on here, and if you could allow Greg to share, I know you guys have the drawings in front of you, but we could throw up the perspective, particularly Greg, that will highlight where this little platform is. Maybe go to the perspectives, Greg, and then it's easier to see it there, I think, than in elevation. Okay, so in the lower left where his little cursor is, you can see right there that, Greg, can you put your cursor on the door, the exit door, right there? That is a door, as you can see, that comes off of the first floor out of an exit stair onto a platform, which in a way actually serves as a covered covering over the entrance into the building, which is on the side wall. It doesn't even face the street. There's a 8 foot wide courtyard that's in the space right about where that man is rendered there in the center where you would enter. But if someone had to get out of the building, if this flooded, they'd be able to get out on that platform and get into a rescue boat and be able to move out. But at least we've created a building here for residents that are safe, and safe on many fronts. Listen, we're talking about a highly sustainable building here too, in terms of how it's insulated, how it's heated and cooled and insulated. And it's a small building, obviously, it's not very big, but that's where this variance then kicked in, because we're calling that edge right where his cursor is, right there where you see a railing, as being the side of the building, but the reality is it's really not. That brick wall that you see there is really nothing more than a garden wall to support that platform.
What's
Inside
underneath
that,
the platform? What's
underneath the platform is a courtyard. Maybe go to a plan, Greg. Hey,
I couldn't tell.
Yeah,
It's
you said-
open
and that's-
air, right, John? It's open air.
yes, it's right there.
The platform, how's it open air? That's where,
Right, it's open air. The platform is open air. The platform's not covered, but that area right here where you see.
but the
that's
platform is, the platform is X feet above grade, whatever X is.
About 12 feet.
Okay, so that platform is made of a material, right, in order to be a platform.
Right, yeah.
So how can you have an open air courtyard underneath it if it's a cover, if it's a surface? I'm not sure, am I,
It's frankly, it's so different than a deck, you know, if you think of it that way.
right, so
You
it's a
work out,
deck.
you're working out on a deck like you would have on any building, and underneath it is open.
But it's not open to underneath it. Underneath, I don't have a deck, so I can't answer. But, oh yeah, do I have my stairs are on a deck? Underneath my deck is nothing. It's not a space.
Well,
you
it's
can go
not-
to. So I
It's
don't
not
understand.
exactly just a deck or open courtyard, because you've got a wall on the side of it. So you have the entrance of the building, you've got it covered, and then you've got a wall on the side of it. So it's not just a protrusion, it's kind of an enclosure.
Right.
It's just open to the front to some
And to the
extent
rear.
and open to the back, yeah.
Right.
Right.
But it's
That's
not
That's
a
correct.
just,
courtyard.
and that's
because-
just a description of it.
So what's underneath it? So what is in the space that Brian just was explaining out?
It's,
You've got two walls to it. You've got
it's
two
a-
walls plus a roof.
it's a courtyard. It's where you enter the building. Greg,
Oh,
can you
okay,
can
so
you
it's
blow
the
this
middle
up a little bit?
entrance.
Blow it up a little bit? And-
Right, you see the lobby?
Right.
Okay, it's
Robin?
the entry court. So it's the entrance. Okay.
Right, you enter through a gate just to the left where it says underground utilities. You see that there?
Yes,
No, those are the utility lines coming in, but you see it, a gate or a door,
So
what looks
that's
like on
the
the
entrance
outside.
to the building.
Well,
and
it's
then
the
you
entrance
go-
to the courtyard. The entrance to the building is that other door to the right where it goes into the lobby.
Right, but you have to go into this space that you're calling a courtyard in order to get into the lobby.
That's correct. And you can walk right through, you mentioned it before, if we zoom out, Greg, we could walk right through this courtyard and you get to the back of the building and to the parking area, right through there. You can see there's little square hexes there, meaning that might be like a blue stone or some type of stone, you know, nice terrace area. Might be some planters that are in here, and particularly in the parts that are not covered. The whole thing is not covered, only to that particular point. Where you see that, and see it says in the back, open entry court, that's not covered.
So let me ask you, is that the only way into the building from the parking area? Or
Right.
is
If
there
you park-
another?
Nope, if you
Go
park your car, let's say you parked in the middle of that parking lot somewhere, right about where he is there, one of those spaces over to the right. You
Yeah.
would walk across right there and you walk into the courtyard. You can jump into the stair, well, if you wanted to, or you could walk down to the lobby, go in, and there's an elevator, which is right between the two stairs, you see. And those are the three means of vertical access in the building, 2 exit stairs and an elevator.
And is it
since
continue?
we're talking
Is
about,
it? Go ahead. Sorry,
oh,
Robin,
no,
go ahead.
go ahead. Since you're talking about the use of, since I was gonna wait for this, but since you're talking about it now, I assume this is wet flood proofed. The lobby and the parking, right? The walls go, right? They flood, they go disappear if there's a flood, so that things go out. Is that correct? You're not dry flood proofing this?
No, we talk about, these walls are concrete, probably finished on the inside with some type of epoxy type of paint so that they, you know, not sheetrock that will get ruined, for example, if it got flooded. But we have to create that, those walls have to have little floodgates to them so that the water actually would enter that lobby.
That's what I'm saying. So it's not dry flood proofed, it's wet flood proof. You didn't build a bathtub, it'll
Right.
get wet. It will get
Correct.
wet if it rains. Okay.
Even the outlets, Robin, are up above, that they're coming out of the ceiling. So in that lobby, there's not even electricals
No,
anywhere.
no, that's fine. I just wanted to make sure I understood how this was when I looked at it.
Right.
That's what I thought, but it wasn't clear.
And there's no basement or cellar below any of those, even the
Well, actually,
elevator.
that's a question that I have. Well, I know your elevator is supposed to stop on the second floor, park on the second or third floor, but this building does not have, is it just on slab?
Correct.
Is it built?
You know,
Okay,
the only
so-
part that's really a slab is that inside of that, you know, stairs and elevator and lobby space. Beyond that, you're outside. Oh, that's on.
So how is is the building, is it built on pylons? Is it built, you know, what type of structure, and how far down do you go with the structure?
Well, you guys are getting into some really good technical questions here. How far down? I don't know yet. We have not done like a soil test yet, but every one of those columns that you see, the little black darkened in squares there, rectangles, those are columns supporting the building. That dashed line that you see that connects, though, that's the outline of the building above. Hence why you see my reference earlier that the parking spaces along the right, that roughly half the car is exposed and the other half is covered by a building. So the structure is supported by typical concrete foundation piers, steel structure, and when we go up and we frame the upper floors, probably it'd be light gauge metal. Frankly, it could be wood.
You haven't done soil test on this, correct?
No, we have not done soil tests.
Do you know if you're going to use piles or you have any?
Yeah,
idea?
no, absolutely, no doubt. If we don't use piles, then we will use large spread footings on concrete piers.
Okay.
And you,
So it's not like you're
you
gonna-
guys can see, it's not a very large building. It's probably, look at the building just right next door. I'm not quite sure how they built that at the time, but I mean, I suspect that there's subsurface conditions here are more than satisfactory to support this light building.
Right, so you're not displacing a lot of soil to put in foundations from the ground all the way up.
No, we're not.
No, you're going on pylons or footings, whatever. Okay.
Yeah, and the site is essentially dead level. There's maybe a 1 foot grade differential across the site a little bit. So there's not even a lot of, other than obviously demoing the building, which you can see over to the left on the survey right there, just maybe blow it up a tad, Greg, so we look at it. But the dashed line is even a note. Those are the outlines of the existing building. The existing building, as you can see on the left side, which is the south side, is literally like 3 inches off the property line. And then in the back, there's some kind of shed that's not a garage. So that building obviously is raised, and here's the footprint of this building. Interesting enough, we're not sure, but I'm sure you guys can probably notice this here, that the building on the right, that the parking structure was built about 10.5 inches onto this site. That's not a drafting error. That's real.
Greg, can you pull up that rendering so we can?
Could
see
you
the
say that
parking?
again? I'm sorry. You're saying the neighboring building is actually built onto your property.
It encroaches onto this site by about 10 inches.
So you've got title issues. That's a whole different.
Yeah, well, I guess we'll have to address that one.
Yeah.
Where's the encroachment?
Along that line, can you see his cursor moving right there? That line, the dark line is the property line, and the thin line to the left of it is the outside wall of the parking structure and podium of the building on the right.
And how long has that been there? That building?
I believe 2008.
So what's the encroachment of it? Just a few inches or?
It's about 10 inches. Yeah.
The encroachment.
I mean, listen, thankfully, it doesn't really impede upon what our plan shows. The site works, the parking, the building, et cetera. But I guess our property owners will have to address this, separately.
Can I ask you, are you increasing or decreasing impervious surface with this plan?
I would say that we're increasing it. For no other reason than because obviously, the site will be paved because it's a parking lot and because the building footprint is there.
I believe actually we're decreasing it by a percentage because it's fully impervious right now.
Yeah,
Like Michael
that's
knows
true.
the answer to this. I think we're going from 50% max coverage to 49.
Because currently, when you look at the pictures and such, it looks like there's open yard in the back, and actually by these drawings, the building is quite a bit smaller. And I didn't really understand that component unless you were using some type of gravel as opposed to paving for the parking areas. That's why I asked the question. There's open grass space right now.
There's very little grass space. The whole site there's no vegetation really on the site. We'll be planting some trees, a few that there are. Do we have, Greg, do you have drawing L1, the planting plan? If you do, we can put that up, and it's probably graphically a little easier to see where planting is. And yeah, there it is. Maybe we just blow that up a little bit there, Greg. Thank you. So color-wise, graphic-wise, I mean, here you go. You can see the outline of the building again dashed. You can see the gray area is the parking. In the rear, there's a little bit of planting and some trees and shrubs that are in those islands in the back. We're planting 2 trees out along the sidewalk, streetscape, to help maintain the street corridor, which exists. So that's the extent of it. And Hudson Engineering has engineered the site and has addressed all of the stormwater retention on the site.
Yeah, no, I
Overall-
understand. I understand about the stormwater retention. I was just asking about the impervious surface. Because if you look at actually, if you look at Exhibit G, I don't know, several pages in, there's an aerial photo of the building. And it looks like that area where the shed is, and also on the side of the building, that looks like it's all grass. It looks like only a small percent, only where the building is really is impervious.
No, they park, the land area to the right of that house today is used for parking all the way back to there's a fence that comes off the back of the house.
Yeah.
I've never really walked myself, back beyond it, but a good, even if it's just gravel, but it's disturbed.
Yeah, well, it's just something that I'm sure we're gonna want. So if you could just double check on that, but I did see that you've got the water retention in place. Which is good, which is relevant.
We've worked very diligently with the planning board, which, perhaps and on many of these items, both from the drainage, as we've been talking about, from the floodplain, how we've addressed the safety of the building and the future residents, how we've addressed the mechanical systems and the technology that we're talking about utilizing for a building like this. We believe that this could be a real nice contribution to this village, and maybe even to some extent with the type of engineering systems that we're talking about could almost be a model. The planning board actually thought that this whole idea of getting no habitable spaces below that floodplain elevation and having rescue platforms was a real good possibility that they may look to for other submissions. I mean, I know we're getting a little field to what this board's deliberations will be regarding the variances that we have here, but as Kristen said, 2 of those variances, the side yard, so have simply to do with this rescue platform, which is really not, as we saw from the renderings, is really not the building, so it's not as imposing off-site, because we are respecting that 8-foot setback along that whole side with the face of the building. So the others are, what they are. And, as far as the open space, clearly, I mean, it's such a small piece of property to put any type of development on here that would then try to create open space on the site when we live directly across from a park. Maybe that's a rational, request on that one. So again, I think if we look at this project holistically, and if we realize even architecturally, how we're trying to treat it to look like there's some sort of continuity to the streetscape and the street corridor that, and with the technologies that we're talking about employing here, that perhaps we have a very good application.
I have some questions for your traffic consultant, if he or she is here.
He had a conflict tonight. He will be available next time, but you know, Michael and John and I are like we said, we've been at this for 10 months. So why don't you ask us and we'll make sure to get you an answer. Because I did provide his traffic study, Brian Dempsey from Provident.
Let me interrupt everybody here. How long do you guys want to go, Robin and Brian?
I'm happy to, if you want to wait till next, let me just raise the questions with you. So you have the questions
Okay.
and then we won't get the answers today. So your traffic
Because
consultant.
we have other things still. Okay, okay.
Let me just, so it's just okay. So I was a little perplexed by your actually trip generation comparison. You have 8 apartments versus the current, you're gonna have 10 apartments versus the current 2. I don't know the bedroom count, you'd have to figure out, but when I
3
did the math, it
bedrooms,
looked like the trip generation was going to be lower in the future, and I don't see the basis for that. Maybe there is a basis for it. In other words, you had a certain number of trips per bedroom if you want, or per apart. You had a certain number of trips per apartment now, and a much smaller number of trips per apartment later. And it may relate to the number of bedrooms you're going to have. I don't know, but I was perplexed by it. So if someone could just explain that. And then I have another question, but I don't understand. Yeah, I was a little perplexed by the number of trips that you were, the trip generation didn't seem to make sense to me. And then it says in the talking about what they use as comparison for this type of facility, I didn't know what that meant. So I wanted to know exactly what the ITE, what comparison they were using in the ITE. So those are my 2 questions about traffic.
Okay.
I will say that I think your, you know, all of the I had one more question, which was about the electric vehicle charging station. The electric vehicle charging station is only for the tenants, correct? It's not going to be used by the public, because you're very hopeful. 4 stations for, you know, let's all hope it's needed. But at the moment, that's very hopeful. So, okay.
You know, if we keep going in the way of California, just give it 10
Very,
years.
it's very forward-thinking. It's wonderful, but you know, that's why I was asking. Okay.
Yeah, you
those
know,
are my questions.
and those charging stations, just to touch on that for a second. First of all, I think we can add 8. There can be 8 parking spaces with them. We show where the 4 column locations are, right? But they will be retractable.
Okay.
Like the kind you might see in a garage, like with guys who have air hoses. So it would be up so that there is no electrical connections. And again, God forbid of a flood, that would interrupt that flow down at the car level. If you pull in and you have an electric car, there's on the column, there'd be a wire or rope that you would pull down your charger and plug it in. You unplug it and it will retract back up. So we're trying to think of as many safety aspects and good engineering aspects that we can employ in this building.
All right. I have no more questions today, so I mean, so I know
All right.
Dave wants to.
All right, well, we're gonna have to continue it. There's other things we
I'm
have
gonna
to
raise
do.
those now because I had them
No,
now.
That's fine.
Thank you.
All right, Brian, is that all right?
Yeah, I did, you know, I still have questions and I still do want the information I asked for because,
And I
you
just
know,
got emails from-
you know, I think like it was described by council, a lot of these the variances that are being asked for, I think of them as like the domino effect. You know, if not for the number of apartments, you wouldn't, you know, you'd have a lesser FAR, you'd have a lesser open area variance. So they all impact each other, and I do think it goes somewhat to economic viability, just in terms of you know, whether or not this is self-created, and I just, you know, I think we're on the right track with this, and I also want to make sure Greta has her ability to ask her questions at the next meeting. So yeah, I'm okay with what we've got so far.
Okay. All right, Ms. Patel, you understand then? We'll continue this, I suppose? That, I suppose we will. Do you want to do that? Should we do that at the beginning of the next meeting? Just start it right there? Or would you- what time is better for you? Usually start 7:30ish?
Well, it's better than 11:30. for all of
Oh, we're
us.
just starting. I mean, come on.
We're happy to do any, whatever the board's pleasure is, Chair.
The board takes no pleasure at 11:30. Okay, all right, so I guess we'll, all right, I'm just thinking, because sometimes people would prefer to go on later, but I don't mind. I assume this is gonna be probably at least another 30, 40 minutes at the next meeting. All right, so we'll do it at the next meeting in October.
Right.
What is that meeting date? Does anyone know? Let me just look.
October 6th.
6th. Ooh,
Brittany, when are materials due for a continued application?
2 weeks before.
2 weeks.
So it would be the 22nd.
okay.
Okay, great.
All right, and
Thank
there
you
are
all
some
for your
questions,
time.
there are some questions that have been posed. Maybe I'll send them to you because they were sent in by email. That's what I was just checking. Okay. Thank you very much. Then we'll adjourn this till October. Thank
David,
you.
I want to ask if anybody's here
thank
from
you.
the public. There are people.
Oh,
out
is there
there.
anyone from the public who has any comment on this? We're gonna basically continue this in October. I don't know if you're here now to speak,
No raised hands.
but they're all sleeping. Wonderful. So we should be,
Lucky.
okay, all right. Thank you so much and have a good evening to you all.
Thank you too.
Okay, yeah, there's a couple of quick items here that we have. We need to meet with council, and the question is, Charlie, your meeting that you're going to attend is in Monday, is that correct? Monday afternoon?
Yeah, Monday at 5 o'clock.
Okay. Well, we need to talk before that. So is tomorrow good for anybody, or how's your schedules tomorrow? There's that, there's about a meeting with BOA, which concerns me because of the hearing that's ongoing and the purpose of it, of the meeting, which relates to some things we'll talk about. There's the FEIS. I want to go over and just get the standards right. So when we deal with that soon, which we have to deal with, we can have guidance of council. We have another issue that's come up about,
All right, if you want to do it tomorrow. Oh, wait, didn't Charlie say he couldn't do tomorrow?
Yeah, I'm in meetings all day tomorrow.
Right, so we either have
how
to
are you
do.
on Monday? Well, see, the problem is, Charlie, it's a big thing in the afternoon. I mean, just as long as you understand that. I mean, if we want, you want to talk about it out loud now? I don't care about that. There's a
If you want
meeting.
to do it Monday, what time can you do Monday, Charlie?
So I think, let me just pull up my schedule here.
Can I just ask, has there been any discussion on the special meeting for 416 Waverly? They've called.
No, yeah, just that's, I'm getting to it. It's on my list there. Next item is meetings. And then minutes.
So I am available starting at 10:30 for the rest of the afternoon.
All right, I'll try to get Greta as well. I don't know what her schedule was
She
on
said
Monday.
she couldn't do anything. She couldn't guarantee Monday or Tuesday, only Wednesday, Thursday, and Friday.
All right, well, we can't wait. So then let's do Monday. Is 10:30 good for anyone?
Works for me.
11 o'clock? What do you want?
I'm not sure about, I would rather do a little later, like noon, if we could.
Sure, whatever you want. Just, I mean, you want 11:30?
Noon would be
12 o'clock?
good.
Noon would be good. Okay. So noon, can you circulate a Zoom on that, please, Charlie?
Yep, you said noon.
Noon.
David, do you have an approximate amount of time that this will take?
26 minutes. How about 30 minutes? 25 minutes, not longer. I don't have the time.
Okay, under
Is
an
that all right
hour.
with you, Brian? Is that good for you?
If it's under an hour, I can.
Oh, yes, it'll be under an hour.
Okay, yeah.
All right. Then we have two other things. We have, okay, is that meeting a public meeting you're going to? On Monday?
Yes, it's a Board of Trustees work session meeting.
And that's a public one.
Correct.
Okay, so that's done. Is that our
Okay,
meeting?
and what about our meeting? I don't have it open now. I can try again.
Well, do we have did we?
No.
We haven't, no. Okay, do we have anything else to do tonight?
You have to try to
don't ask
figure
a
out a
question
date for
like
the
that.
FEIS.
Sorry, what did you say, Brian?
Well, we have to figure out a date for the special meeting.
yeah,
to
that's what I'm-
review the FEIS.
Right. Brittany, do you have those dates handy? I'm sorry to trouble you on that.
Or I could get them.
All right, I'm sorry. I'd circulated them, but I don't have my thing open right now.
Okay, so this is based on the courtroom, assuming we have to go back to in person or you want to be in person, the end.
How long is the executive order now for? How long is the?
13th of September is the next extension date,
Oh, so
end of the extension date. So the courtroom availability is September 9th. That's obviously out. September 15th, 16th, 19th, 23, 26, 29, and 30.
Okay, so the 15th is the
I
Thursday.
can't do any Monday, so I just say that now, no
Yeah,
Monday.
so, all right, so I don't think we want to do Friday evening on the 16th, and not with me anyway. So what's after the 15th? What's the next one after that?
15th, 16th, but that's a Friday. 19th is a Monday. 23rd is a Friday. 29 is the Thursday, 29th.
Okay, so. All
I
right, so
could do either Thursday. I could do either Thursday,
which would be the, hang on,
15th or
15th
the
or
29th.
29th.
Brian, you didn't get,
Yeah, those two dates are okay. 15th or 29th.
Okay, what I'll do tomorrow is I will, and then if we do the 29th, when's our next one after that? It's gonna be the 6th, right?
Carly, the 15th was chosen though. Would the applicant have enough time? Don't they need to continuously update their sign for these meetings?
No, because we're just having a work session. This is not, I mean, this is just, we're just gonna be dealing with the FEIS, Charlie, is my understanding. There's not a public hearing on this, correct?
It's not a public hearing, correct?
So they have to have a sign then?
I'll have to check. I mean, I'll have to look at what the code says. Typically, I think, Brittany, they do update their signs.
They have been, yeah, every
they
time.
have to
and-
update for public hearings.
Yeah, but that I don't think, well, you'll check that. I'll check with Greta. I'll send her a text. So it'll be the 15th or the 29th, but you know what you do? Let me know in the morning, Charlie. And what time will we do? 7:30, I guess? You want to do 7:30 PM? Not earlier. You want to do late? I mean, how does that suit everybody?
That's fine by me.
Okay, okay.
Did you say the 15th?
Well, I'm gonna check with Greta, the 15th and the 29th, and Charlie's gonna check tomorrow on the effect of the signs. And yeah, Charlie, if you want to ring me in the morning, you'll find out, and then if it's clear with Greta, then you can find out on the next step, which would be,
I'll email you very early in the morning because my meeting started around 8:30. So I'll get the sign question nailed down before I'm unavailable.
okay, and then Monday is Zoom, Monday noon. Zoom, okay. All right, and do you have anything on the, well, I guess, I've got your position on the privilege issue. All right. Okay, So we'll go from there. Super. I think what the minutes we'll have to deal with next time. And I also think if we're gonna have this, do we have any applications that have been filed yet, Brittany, for the next meeting, October? Brittany, are you there?
I said, no, we do not.
Oh, I'm sorry, I couldn't hear you. I mean, if we have two already that are gonna be on, right? I mean, this one we just had, and then the on Amerenik Avenue, correct? I mean, how's the board's thought on this? I think there's too many. I mean, we're gonna start to have 4 or 5 others. It's just gonna be, it ceases to have that same productivity, I think. I'd rather.
I
let's-
want to have more meetings. I'd rather have a longer meeting than more meetings.
No, I don't want to have more meetings either. Yeah, well, I think we'll get rid of a few items here, but I'm just saying for the next meeting.
There's only
Right.
2 public hearings. We can have more than 2 public hearings.
I think it's a 6.
No, we can have 2, but I don't want to have 6 or 7 is what I'm saying, depending on the size. There's special,
Application states 6, so we would have to change that, which the application really does need to.
the application.
Stated in many ways.
It does, but I think it says up to 6. I don't think it says
Yeah.
number.
I mean, if we could put it as a set number, it would help at least my, arguments with people if I denied them on a meeting.
We just tell them to come in at 11:30 at night. I mean, what do you want me to tell you?
If you're willing to talk at 11:30, then feel free.
Yeah, well, you may talk alone then. Okay. All right, so 9, okay, so I've got the dates there. We have those. We have the Zoom on Monday. I just think we're gonna think, I don't want to have, listen, what do you think, Brian and Robin? If we have these 2 that we have, I figure are gonna be an hour and a half right there. Okay,
Well, which ones,
you have the rest, the one with the violations, which is gonna be a bit, and then you're gonna have the one we just had now, right? That's gonna be involved, and we had a pile of emails, that's what I was looking at on that from other, what do you call it?
right, and we're still gonna have to have time to deal with 886 Orienta Avenue.
Yeah,
Yeah.
I mean, I guess we could take at least 3 others, but it really depends on what they are. Brittany, when you get them, why don't you just let me know, give me a ring, and we'll see what they are.
Yeah, the deadline is next week, so the 15th.
Okay, I think that's the best. I hate to just make a number up, because it really isn't the number, it's the substance of each one. I mean,
The problem, Dave, is even with the substance, you sometimes don't know.
oh,
It
that's
seems simple, and then you really get into it and you realize it is much more complicated.
absolutely. But I think we now know that there's gonna be one that's gonna be a little bit complicated, and then this last one is gonna be, there's a lot there. And some, one of the committees from the villages sent half a dozen, you can look at them online, but they sent like a half a dozen questions on this. They couldn't be here tonight. I was thinking about it.
Right, that was from the flood committee.
Right.
And
Wait, the flood
you're
committee
right.
has questions on the current application, this one that we just took.
Yes, although I think much of that should be resolved by the neg deck.
Isn't it resolved by when the planning board reviewed it? Wouldn't they have considered all of that?
Well, yeah, I think if they neg decked it as saying it's not an impact, I don't think we can then say it's an impact.
That was stated at the last planning board meeting when the flood committee tried to speak. That exact statement was made.
Right.
All right, well, what I have found is just to tell someone that and to discuss that, even if you prevail on the discussion, is still a 20-minute deal. All right, well, let's see, we'll take it up next week on that, but we'll talk on Monday. We'll have those dates fixed out for you on the 15th of the 29th, and we'll go from that. All right, Brittany, so I'll let you know next week on the 15th of the 29th.
Okay.
All right,
Thank you.
then on the, we'll go from there. Okay, super. All right, good night and have a good tomorrow. Have a good weekend, everybody.
Do we have a motion to get off of the Zoom?
No, you stay on then if we don't make the motion, Brian. You are the night guard, the night keeper.
Close, I make a motion to close the meeting.
Only if you, okay, and everyone in favor leave immediately.
All right.
Have a good night.
Good night.
Are closed. Thank you.